Yeah! Welcome y'all, the gavel's calling. Let's get this session started. Hey folks, grab a seat. It's time to get the scoop. Bakers in session, serving justice with a whoop. From sunny Cali courts to the heartland's dusty halls, we'll spin the yarns of trials big and small. Oh, Baker in session, tales old and brand new. Some make you laugh, some will leave you in a stew. Gavels dropping beats, witnesses take the stand. Join the fun, y'all, across this great land. Hey. Classic papers like OJ or that moonshine bust. Fresh headlines steaming high, in Baker we trust. Murder in the Midwest, scams down south so sly. We'll break it down with grins, no need to cry. East Coast embezzlers, West Coast wild rides. Supreme Court showdowns where the big shots collide. From petty thefts to plots that twist and turn, Baker's got the stories that'll make you learn and burn. Oh, Baker in session, tales old and brand new. Some make you laugh, some will leave you in a stew. Gavels dropping beats, witnesses take the stand. Join the fun, y'all, across this great land. Famous folks in hot seats, underdogs who win. We'll cheer the verdicts, dive right in. Coast to coast adventures in the name of the law. Baker's here to share it without a single flaw. Hit subscribe, don't miss the legal ride. Baker in session where the laughs collide. Fade out, radio roll.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any that you might be or might not be, or maybe you are in between, so you are a little bit of this or that. Happy Turkey Day to all of you Yanks, and as we all know, today is the day where we settle down and say something that we are thankful for. I'm thankful that they had a used part for my car door, so I only had to pay $400 to have it fixed instead of paying $1,000. And Catnut Williams, thank you for 3 months and sends all the weird American food. Happy Turkey Day. Happy Turkey Day to you as well, Catnut Williams. And I hope everyone is having their turkey in the deep fryer, on the grill, whatever you're doing with it. I don't know. Turkey is a boring piece of meat, but we used to have it every Christmas. As we normally do on holidays, we are gonna do a couple of hours or however long we are going, because some people might sit at home and think, I have to work tonight and my family is across the country, so I am just going to get this turkey TV dinner, and then watch some telenovelas, and or maybe you are at home and you're looking out into a room where there's more than 5 people. More than 5 people is torture by the definition of the Scandinavians, and you need to just go into the toilet and pretend that you had Taco Bell yesterday and need to come relax, hang out with your friends in the chitty chat. Or maybe you are so lucky that your spouse is the one cooking all the food that you're going to eat later, or you have to go to your dads and moms and friends, daughters, son's house and eat, and you just need somewhere to pass the time. That's why we do these holiday streams, to make sure not everyone has to feel alone or overwhelmed. My Thanksgiving morning include listening to my 24-year-old daughter who, Mom, I drank exceeding too much alcohol last night. Oh, to be young and dumb again. Purple Pixie, at 24, she will sleep 2 hours and then she'll be ready again to eat and party all night long. I don't know how, because again, we don't do Thanksgiving. We didn't need Native Americans to help us out. We learned by ourselves to get food. But in Denmark, a day like this, if tomorrow is a day off, we would be out at that age getting drunk with all our schoolmates. Just because it's Denmark, we drink a lot. Just me and the 3 kiddos. Well, that's the perfect amount of people. Don't overdo it. That's the thing. Whenever we see these Americans things with hundreds of people at a wedding, my wedding where we combined almost both of our families, I think we were 30 people. My daughter's baptism earlier this year, I think there was maybe 25 people. Way too many, but still way less than most people are seeing in the Americas. Wednesday before Thanksgiving is the biggest party night of the year. The 25th of December is the biggest party night in Denmark because everyone goes home to the city that they're originally from to visit their parents, and then you'll have your Christmas on the 24th, and on the 25th you will normally have like a lunch thing where you'll eat all the leftovers or whatever tradition you have, and then the young people will then go out and meet up in town at normally you'll go at 11 o'clock, and then you'll party until you can't no more until the nightclubs close at 5-6 in the morning. That's how we roll on our biggest night. Second biggest is probably J Day. J Day is the first Friday in November. That's the day that the Christmas beer, because Christmas in Denmark is called Jul, which is spelled with a J. That's the night that those beers are released, and the breweries will then send out scantily clad elven maidens or men in not that much clothes, and give you a free beer. And every year you forget that it's made on boxing gloves and condoms. Either you want to F or you want to fight when you drink them, and you'll get hammered like no day else in the year. And there will be puke and fights everywhere, and maybe a few sexual encounters. I don't know. I am a virgin. We got married at the courthouse. It was just his and my parents and my 2 brothers. Perfect amount. My sister got married twice. She got married at the courthouse in Copenhagen and then in a church in Rome. I think we were 10 people at the courthouse here in Copenhagen to see them, which was a lot. It's just going to be my mother and father-in-law coming over. I know for a fact it'll develop into a shit show because I have cancer, and they'll beg me to go through chemotherapy. Well, do whatever you can and beat that mother effer out of everything. Baker is saying Danes are boring and don't know how to have a party. No, Baker is saying that we don't want to clean up after you. So whenever we are having a party, we'll rent some Boy Scouts hut and have 40 people there, destroy the place, go into town, go to a nightclub. Having 30 people at your house is just a lot of cleanup that you don't need to do. Berkeley Farm says, good morning to my fellow Americans. It's just past 6 a.m. where I am. Going to have coffee number 2 and make the first dessert. What are you having for desserts? What's pie? I think pie. You eat a lot of pie at Thanksgiving, I think. But is it pumpkin pie? I've never had anything pumpkin other than my mom. My mom went a little crazy back in the 80s, so she would do all these weird things. So she made like what do you call it? Where you cut it up and put it in a glass with something, and then you'll leave it, and oh, we can eat it all year, and it'll taste just like when I never ate a fresh pumpkin. So how the hell should I know what it tastes like 6 months later after it's been in some stupid jar? Preserved pumpkin. Yeah. This year is the first year I saw pumpkin spiced latte at McDonald's. I don't mind a chai latte. Well, I do mind. I don't know why I like them. I don't like them, but I like them. It's one of those weird things. Every time I buy them, I think, why the hell did you buy them? And every time I finish drinking them, I wish I had more. Probably because it's 95% sugar. But at the same time, I think they taste weird. That's my wedding was the smallest in my family at 85. 85. I don't have 85 ancestors. And my family got traced back to 1200 and something. Lemon bars, brownies, and pies. I don't much like pumpkin pie. I have some pecan pie, and we usually have berry pie. I like a good apple pie. A good apple pie with some whipped cream. Mm, 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 mm. I'm boring. I do not like pumpkin anything. I don't think you're boring. It's just you might be not a trend chaser. Maybe you are your own person. Since you're in Denmark, I need to know more about the Nagel family that moved from Copenhagen in 1892. The guy that built this house is Viggo Nagel, born in 1890 in Denmark. I don't know him by name. Maybe he's famous. It's not this guy. Nothing pops. The only Victor Nagel that pops anything is someone who fought in the Second World Kerfuffle for the Americas, but he's born in 1924, so it's probably not him. And Nagel is not a Danish last name, so I don't know where. At that point, he would have been a son if he had been Danish. So they probably changed the name when they hit Ellis Island. I am doing an experiment based on tasting history and making Indian pudding, cornmeal and molasses cooked in milk. Either it's going to be kind of like a very caramelly creme brulee, or it's going to be... Can we ship a pumpkin pie to Denmark, or is it contraband? As long as it's factory sealed, you can ship foods. But again, I've never tasted anything really pumpkin other than preserved pumpkin. I'm not a big fan. I went to the wedding of a friend from uni in Amritsar, India, the Golden Temple. They had about 6,000 guests over 10 days. It's not necessary. The wedding isn't better because of the amount of guests. I'm just going to tell you, I know I'm going to spoil all of your dreams. Just because you have a lot of guests to your wedding doesn't mean that the marriage is better. It just means it's more expensive. And price isn't quality in a marriage. Hey, Sui. I like rice pudding, so I think I'll be fine. I'm going to eat it with whipped cream on top. You don't put whipped cream on a rice pudding. You put it into the food. Baker and Iris fight about how many guests. No. I know Iris says it's not a Wednesday if there's not 56 people in her house just stopping by for a bit to eat. And I don't think I have had a guest in my house since my daughter was on vacation down here. And I'm perfectly fine with it. Oh, on the cornmeal pudding. Yeah, that sounds Yeah. Sue has almost every dish prepped. One more to go. Well, good to hear, Sue. Then I'll be at your door in 7 or 8 hours. Maybe 10, 15. Just need to find a plane. Hey, Hyacinth, been a second. Well, since you had to get baptized, the church kept the records and you almost married. You also married in church. It had more power than it has now in most of Europe. Yeah, as I told the other day, when my kids were born, I had to go to the church within 5 days and had them registered. The churches were the one who made sure that everyone was registered who was born in Denmark. Even if you're not a Christian, you had to go to your church to be written into the church book, and is then the priest's job to send to the government. It has been changed since then, so now you register just with the government. But back then, everyone had to go. You had to tell them how to spell the name, and that's how anyone got registered in Denmark. When my mom did our family history, they had all the old church books that survived. Some of them had been burned and stuff like that whenever it happened, but they have them all on microfilm, so you can go in and see books. I think the furthest back she got was somewhere in 14, 15 something, and all of that is still preserved, so you can go back and find your family. Because in Denmark we had this rule that if you were not a landed gentry, you were owned by the people who owned your land. You just belonged to them. We don't call it slaves, but that's what we were. So you couldn't just move around. You had to have permission from the guy who owned the land. If you wanted to marry someone, you had to have his permission. If you wanted to move, you had to have permission. So most Danish families will be within a very, very short radius until roughly 70 years ago. That's when people started, okay, we're going to move a lot. But back in the day, most families will be trackable within a maybe 20 miles radius is where they have lived, because people didn't move. First of all, you didn't move back then, and second of all, you were slaves. So that was just how it was. We belonged to this duke or baron or whoever owned the land. That's where you had to stay, and you had to work at his farm, and that was just how it was. But because it was different, we didn't call it slavery. We just indented servitude. It's different, but the same. My sister's wedding had over 100 people for her wedding. I vowed to never have a large wedding. My in-laws got married at the parsonage with just parents and siblings attending. They lasted 60 years. Yeah, it's not the size of the wedding, it's the size of the. Well, I can live with this widow. Yeah, it was serfdom or fiefdom, but it's slavery the same, because you couldn't do anything. You had to work for your lord, but you didn't call it slavery because we were just peasants, and peasants didn't have any rules. It was different back then. It's a simpler time. You didn't have to know what education you want, because no one had an education. Well, that's not true. Denmark actually was one of the first who had mandatory schooling for all kids, but still, my dad went to school, I think 3 or 4 days a week, and only to the 7th grade. And they were, I think there were 3 grades. So first, second, and third grade would be in the same room, and you just had to figure it out. And that was in the late 40s. My dad went to school. But yeah, that was the big old good old days. But again, it makes it really easy to track your family, because the only foreigner that my mom ever found was on my dad's side of the family, who was a Polish guy who came up here to help on farms, to I think actually to grow potatoes, and I think he came up here in 1700. So I am partly foreigner. I'm not pure Danish, but almost, because my family, they lived 2 spots in Denmark and nowhere else until, well, my dad was the first one who didn't become a farmer in his family. I'm named after a farm, actually, because when they finally got money enough to buy the farm, they also bought the name of the farm. So that's my last name. So I don't have one of those son names like so many other Danish people have. Yes, and Fedorowski has a new video up today. The forest that borrowed his shadow. Seems interesting. Maybe it's something tonight when you have had your turkey and meth and you need to calm down. Go check out Fedorowski's new video. Hey, Deirdre. Happy Thanksgiving to you as well. We usually have turkey on New Year's Eve. We had it at Christmas. Some of us are still peasants and heathens. Well, we are not heathens, because since 1564, the king decided that we were all, well, 1200 was when we all became really good Christians, because we went out and beat everyone else, so they became Christian. But after Luther reformed the church, and there was the 100 Years' War, the king decided that now we were all Lutheran, and we are paying a church tax in our tax system. So we are all good Christians. We are not heathens. And as a tax-paying Christian, I don't see how God can keep me out of heaven, because I pay taxes. And taxes is more important than anything else in a socialist society. That's heathens to say. Yeah, it's fine. I'm goofing off in my official listening to the Broken Baker Thanksgiving stream, waiting for the game to start. The Pittsburgh Red Raiders versus the Leominster Blue Devils. Oh my. I don't know what that is. I don't know where those places even exist, if they are real places. In Scotland on New Year's Eve, you have steak pie. In Denmark, you would normally have what we call hamburg, which is a boiled piece of pig and some stewed green cabbage and caramelized potatoes, or you'll have some cod. We've never been big fish eaters in my family, so we always just had the pig. Hi, Dan G. Yes, go check out Fedorowski's newest video drop. Everyone's socialist except the 1%. Yeah, they're extra special socialists. Just got here. Were you able to get your car door fixed? What did it turn out to be the issue? Apparently, the locking mechanism wouldn't trigger on the signal, so it'll just say, and because it then didn't lock, it will go back, run the cycle again, and so I had to have the entire mechanism out. And he called me and he said, "Well, if you need a new one, I have to send for it. It'll probably be a couple of days, and with installation, it'll be roughly $1,000." And I said, "And now give me the good news." Well, we have a used model that we actually have right here from an old car, and you can get that for, I think I ended up paying something like 400. So the car's working again. There's no alarms going off, and the doors are locked. So that is going to be grifting a lot. No, I don't, because that goes into my company account, and I don't get any money from that anyway. I miss being driven in a horse and carriage. Are you that old? Too much electronic in modern cars. My car isn't modern; it's 11 years old, so it's not that new. Hey, Jen. By the way, talking about El Grifto, I said it yesterday that while we are in Thanksgiving mode, if you want to contribute to Aiden's Defense Fund, I would put up the link and pin it to the chat because, as we saw yesterday, Kosi G, the man, the myth, the absolute bellend, filed his motion to claim that the motion filed by Betero was not a motion but was just, and he deified Aiden. So Aiden is no longer Dr. Daddy; he is now Dr. Saint. So you should all, you all have to call him that from now on. And if I'm hoping one of my mods might put the link in chat because I'm just talking out my ass till it comes in and I can pull it up. So if you want to contribute to his defense fund, because this is going to be another kick it down the road. We were supposed to go to court next Friday, the 5th of December. They're still going, but it's not to argue the motions. It's I think there's like 4 points on it. They're making a joinder of it, and it just seems so stupid that, first of all, they should just drop it. We all know that. But it seems like the Commonwealth will do anything to drag this into a courtroom tooth and nails. And with yesterday's other motion that was approved, even though it didn't seem like Proctor had okayed it, the McAlberts moved the civil case from Karen Read into federal court. By doing that, we will not be able to cover it. Thank you, the kid. Gonna pin this to the top. And is that Mr. Ray from Dallas? Hello, Ray from Dallas. You need to go and get some sleep. You've been streaming since I got up this morning, and you must be so tired. He was streaming the Aiden's Call-In show from the other day. And Anime says, I hope everyone can find something to be thankful for, like the fact that Baker's always be grifting so you have a stream to watch when you don't want to see anyone else. Baker can be thankful most of the mods aren't around to yell at him today. Oh, they will yell. Don't forget to let Baker know just how thankful you are for the stream by leaving a thumbs up. I can't believe Baker doesn't know the real history of Thanksgiving. It has nothing to do with pilgrims or Indians. It's a Dutch Thanksgiving. That was from Squabby, the last one. There's no Canoni to save them in federal court. They are effing nuts. They don't want the cameras, but don't realize that effing stories ain't gonna fly in a federal judge's courtroom. Big Earl, I wish that was true, but I have also seen the level of competence that the SJC judges have, and I'm not impressed. And again, there's different rules for evidence in the federal court as well. But as I made a video, not many people go and watch it. I don't know why I make videos. I got like 300 views on it. I think they're good. This is probably a really big, stupid Barbra Streisand moment for them. Because by putting it into federal court, I will not be able to stream it. I would have to rely on boots on the ground who will be in the courtroom, who will either live stream it on the Twits, or who will come and give updates later. And then we will start to wildly speculate. So, as I argued in my video, them going to federal court in the short term is a PR win for them. It'll keep all of us away, the Karen Read army. But at the same time, they have figured out that they are still, even though they are out raising the shit of Karen Read in funds, they still don't have the public with them. There was a big group out there who believed Karen Read was guilty, because most people are insane and thinks anyone who is charged with something must be guilty of something. So they raised somewhere around 50. I haven't looked how much it is. I saw 50,000 yesterday, and Krusty Panties might have moistened her panties over that, because oh my god, we're so popular. But they were starting to talk about, we need some YouTubers to be on our side, because no matter what, if you close the doors so we can't look in to the courtroom, we will still cover it. And I think we will cover it more now, because to be completely honest, I didn't see me covering much of the civil trial, because it's going to be boring motion after boring motion, where it's just going to be the same arguments over and over and over and over again. We're not going to see the depositions. We're not going to see all the nasty stuff out there, because most of it will be under gag orders. So it was going to be a really boring trial. So I was like, okay, if anything interesting comes up, I'll cover it. Also because I soured a lot on the Free Karen Read movement with all the bullshit that's been going on since September. I'm just being honest with you now. It's Thanksgiving. We can be honest. So I thought, well, I'm going to cover it if I see something interesting. Now, by claiming I can't look at it, I'm going to look more. Because why won't you have me look at it? What are you afraid of? Oh, is it because you lied on the stand multiple times? Is it because you are a known liar who want to keep everything secret? You want me to talk less about you? I'm going to talk more about you. I think it's a really stupid move. It probably won't go to trial before 2030. I think 2027 is probably a decent bet for it. Karen is suing them. How can they get it moved to federal? Because they asked for a venue change because they believed it was in the federal, and the judge agreed and sent it there. McAlbert's raised a lot in the first 3 days. Since then, they have only had about 3,000. Looks like family and friends made the majority of the donors, not the public. It doesn't matter. It's a PR win for them that Karen Read raised bupkis, while they raised 50,000. People will only see those numbers. Karen Read's fundraiser that Alan Jackson put up didn't raise anything. And in the eyes of, if you had a good YouTuber out there, let's say you could sway someone who was a pretty decent YouTuber. Don't use Twisted Tragedies, don't use Plevin, don't use Grant, don't use the Cruster. But if you had someone who was a little bit less despicable than these people, let's just we're gonna do something. Let's do this. Hey everyone, and welcome back to a new coverage of the Karen Read trial. As you all know, I was really big into the Karen Read trial the first go around. Karen Read, who was found not guilty in a court of law, has now turned everything upside down and is suing the witnesses, which to me seems odd. Why is she going so hard? I know they tried to use the third-party culprit, but they dropped it for the second trial. Was it because they were just trying to go out there and raise the media against the McAlberts? Why are she going so hard? Yes, there are certain inconsistencies, but was that just because Karen Read was good at putting things in the media, painting them with a dirty brush? I don't know, but why would they go after them that hard. And it looks like the public is actually on the side of the McAlberts. Both sides put up a fundraiser to use in the civil trial. And while Karen Read, who famously raised over $1 million in the first trial, she's now incapable of raising funds. It seems like everything has dried up, maybe because people saw who Karen Read really was. And now they see who the victims of the Karen Read was, the real Karen Read, because the family she's attacking right now have raised over $50,000. $50,000, ladies and gentlemen. That's not a small amount of money. It's still a lot of money that they will need to use to combat this PR machine that we know Karen Read established in the first trial to make all of this into a spectral. She always claimed it was about justice for John O'Keefe, but this seems more like she's just vindictive. Why isn't she trying to find the John O'Keefe's murderers? Why is she just trying to hurt people she didn't even know? And there's no evidence, no charges. And now she's going out here and claiming that they are the real culprits. Well, the data speaks for itself. Karen Read might have won in a criminal court, but it seems like in the public eye, Karen Read is losing because she can't keep up with the McAlberts. And if you had someone who could do that, who could seem quite normal, and who would fight for the McAlberts, hey, maybe give them a little bit of all that money raised. You can actually start getting out there and do some damage. Just look at how bad the Free Karen Read movement is fighting each other right now. There are people out there, I bet you, if you got someone who isn't a raving lunatic who is sitting on her fat ass in a pink gamer chair begging for money every day, if you had someone who just went out there, who looked kind of like they had a shower once a month, and who didn't sound cray-cray, you could sway some people, because people are willing to believe all kinds of things as long as it's just on the internets. I think there is an army of normal moms. I can tell you that if you go to court TV, most cases, 93 to 97% believing everyone is guilty, no matter what, is the norm on court TV. The defendant should never be allowed to speak. The defendant is always guilty. And I think if you had, let's say, who could you get? The problem is they don't really have anyone over on that side who could do it. But let's say you could get someone, I don't know who you could get on it, but someone with a little bit of fame, like a Lauren Mathis, when she's done with her I copy everyone else's homework problem she's in. If you could get someone like her, because apparently she's more than willing to do everything to fill her pockets, even copyright strike victims' families, and you can get her to be pro McAlberts, you could sway a shit ton of people. And as we saw from the first trial, there was a lot of people who needed a little bit of convincing. A lot of people had to watch a few different streamers before they said, well, there's something fishy going on here. And if Karen Read hadn't had all of that support, I'm not sure she could have raised that amount of money. Court TV is just like your typical jury. That's why I say every time you go in front of a jury, there's 85% chance you get convicted. Hey, Hulda, how's Gran Canaria? Is it hot and nice weather? You just screwed with my head. I had zoned out a moment thinking about Cox's emails and Baker went crazy. Well, I'm just going crazy because everyone else is going crazy. Get Ray from Dallas in on it. Imagine, no, he wouldn't do that because he's a G. But get someone like that, and someone who has a good following, and who hasn't been in the trenches in the first battle. You can sway a lot of public because a lot of people are out there who want to dislike every one of us because hey, I'm a fat Dutch guy with Down syndrome, so why would people watch me? Yeah, if Debbie Dapper wasn't so crazy, she would be the perfect. She would be the perfect candidate if she wasn't absolutely insane. If she could keep it together and didn't stray into Wendy Murphy territory, because she has her platform on Court TV, or she had. If she could go on Court TV like Plevin did the other day, the problem is Plevin can't form a new sentence. He says the same things he's said for the last 3 years. But Kathy Daffy, if she could just stay out of people's driveways, and we didn't have pictures of her sitting in a bar looking like she had more than one drink, she would be the perfect one because she looks like the audience. Because there's no way of hiding it. Every true crimer out there, our majority audience is ladies 35 years plus. And the big true crimers are often the ones who like to delve a little bit into some chitty chatty, because I'm not sexually profiling anyone, but there might be something about chitty chatting in that age group. I'm just saying. Even Bruce Rivers is looking at the civil case. I would so love him and Baker to do a live together. Different sense of humor, but it would be fun. I don't know who Bruce Rivers is, but he is probably hilarious. No, this is a taped presentation I did yesterday. In about 5 minutes, Jamie's going to come on and she's going to do her world famous interpretation of the deep fried turkey in an interpretive dance form. If you weren't here last Thanksgiving, you're going to love it. It's going to be roughly 2.5 hours long. She promised me this year there's going to be some breakdance elements in it, inspired by the Olympics. But normally that's what people come for on Thanksgiving, the 2.5 hour long interpretive dance of the deep fried turkey. You haven't seen Thanksgiving till you have seen Macy's Parade is nothing compared to Jamie's interpretive dance of the deep fried turkey. Bruce Rivers is a criminal lawyer on YouTube, has over 4 million subs, and has a catchy theme like yours. Well, I will almost guarantee you one thing. If he has 4 million subs, he's not coming on with me. Not that I don't think he's a nice person, but you don't go slumming it when you have those channels. Why do you need Miss Jessica to show up? She outed me this morning saying that I'm looking for a house with a Smex dungeon. The Detroit Thanksgiving Day parade is the best parade ever. I have never seen I know the expert is showing it on his channel. I don't get. Maybe it's because I played in a marching band and went in a lot of parades. I don't think, oh my, let's watch that. Normally it's cold as hell and we just have to stand there. So on Thanksgiving, you have decided to bore us all now instead of ignoring us. Thank you so much. Can't wait for all of your famous rants. I really don't think you will bore us. I don't ignore you. When have I Betsy, you've been here so long, you know I don't ignore you. I just don't see you. I need my glasses. Getting new glasses next week. So we need a Kerry Roberts saying she only technically lied. Same with Jen and the Fed. Yeah, that's use those clips. Every soon to be 27-year-old virgin needs a Smex dungeon in the house. Apparently, Miss J says that's what I need. Then I will finally punch that V card. The weather for today's parade is not ideal. It snowed last night and it's cold and blustery. I drove my car out to the to the mechanics this morning. I had to be there at 7:30. That was early. What do I say? I was up at 4:30 anyway. And then I thought, well, F it. I don't have my car. I'm not going to go to the gym. I'll just walk home. It's I don't know how much. It's 7 kilometers or something like that. Put in my earphones and just started walking. And it was still dark out, but it was cold. It was like 3-4 degrees. But it was that clear, good winter air, where the wind isn't blowing too much, and it just feels crisp when you get it in you. Then when he came to pick me up and drive me out so I could pay for it and get my car back and stuff like that. And it's raining, and because I had taken my pre-stream shower and all of that, so I'm just in my shorts and a hoodie. Oh my God, it's cold. I hate the rain this time of year. Boom, 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 boom. Hey, Holly Mac. Why do cars have to be so expensive soon as you take it in? Usually $400 or $500. Well, I don't know. I talked to my brother. He lives over near Copenhagen, where everything is more expensive. He said he can't go to a mechanic without it. It's $1,000. Sneaking in a workout made bacon and omelet. I wish I could sneak in a workout, but sadly my car's been gone since 7:30 this morning, and because I don't know when he was going to call me, I couldn't go to the gym. But I was supposed to be in court tomorrow. Well, I called court Monday and said, am I supposed to be there Friday? And I said, no, you're supposed to be here the 4th of December. I said, that's weird because I have Friday in my calendar. Am I doing this wrong? And she said, well, no, I can't see that, but you have a date on the 1st of June next year. Maybe it's been moved, and I said, yeah, I know you called me one day and asked me about that. So maybe I forgot to move it, but I don't have anything on the 4th. Then I got a message the next day that I have to be in court Friday. And I was like, what's going wrong here? And then when I was supposed to go meet with the guy who brought me my car, they called from court that the court date I have tomorrow has been canceled. And then I said, was I supposed to be there? Because I hear everything. And I was supposed to be there. I said, can you check if I have to be there on the 4th? No, you don't. The case on the 4th is one that has been continued since 2022 that I have never been in on as a layman. But I'm listed on it in the log at the courthouse. So we don't know because he went in and looked. There will always be a report, court in session. This one is the prosecution. This is the defense. This is the judge, and these are the laymen. And he said, you're not listed on the case, so why the hell you're standing on the ones who need to be called? I don't know, but they're going to figure it out. Do we know anything about the Judge Baker for this case with Karen? No, we don't know anything about any of the federal judges. He's going to be an asshole like every other judge in Massachusetts. Maybe not the biggest, but he's going to be an asshole. Are most Danes as intelligent as you? I'm not intelligent. I just talk a lot and try to use big words like deified. I don't know. I haven't taken an IQ test in a long time, but I think we are very well-educated people. But education is not intelligence. Education is just that you can sit on your ass for a long time and learn what's in a book. But we are very highly. Our literacy rate is really high, and our education levels are really high. So we have a good basic education. So most Danish people will know probably more than most Americans about the world and stuff like that, because we are 5 million, 6 million people. We need to know a lot because we are not enough in ourselves. We do a lot of traveling. We work a lot with international companies. So we have we have our focus outwards. You are such a big country, you have your focus internally, so you don't need to know why are Sweden occupied with people who could be ancestors of crusty panties. You don't need to know that. You just need to know that you hate them. We need to know it's because they cheated at war, they stole our land, and any day now we're going to start a new war with them and show them who are the boss. So we need to know this stuff because we have the sneaky Swedes next to us. You have Canada and Mexico. They're not going to attack. Am I into genealogy? No, my mom was. It doesn't. I'm not a I live in the past person. She found something interesting that apparently back in the old times we had our national assembly had two chambers, like the peasants and the merchants, and one of the peasants was an ancestor of mine who written our declaration of our modern democracy. I thought that was kind of interesting. She found out that one of her cousins got shot down 2 weeks before the Second World Kerfuffle ended, sadly in a German plane, but we don't talk about that. She found out one of my dad's ancestors robbed a bank, ran off to America, and as far as she could find out, might have been one of the first investors in either GMC or one of the big old Detroit car companies. But when she passed away, we have all of her research, and everyone in the family have it. My brother has all of it. I don't think I have it at my house, but she went back and figured out who is who. Oh, and we had a kind of miraculous lady in our family as well. She used to be a chambermaid at a castle on an island called Long Island in Denmark, and which what in something that was very uncommon for a peasant girl as she was, because she was just lowly. She got married to a miller. A miller was a really, really big thing because everyone needed to go to the miller and have their grain milled. And magically, the miller was on the island owned by this lord who owned the castle. And magically, this woman, even though they had only known each other for 6 months, gave birth to a healthy baby. That shows you that if you love each other enough, you don't have to go 9 months to make sure that the baby is fully formed. Babies can grow to full, ready to be born mode in just 6 months if you love each other enough. That's what I believe is what happened. Some evil tongues might say that the baron knocked her up and then shipped her off to the miller to keep her silent, but I believe it was love, because I believe in love. My grandparents in Estonia owned a mill, so they were pretty wealthy. Millers were pretty wealthy because they got, I think the price was like 5 or 10% of the grain that they sent through the mill. So they made quite a good living. Hey, Cindy, happy Thanksgiving to you as well. Baker isn't smart. He thinks Australia doesn't exist. Lol. There is a song called Australia Does Not Exist by now. I'm really smart because I know Australia doesn't exist. Again, I've Emspire is sadly looking out of the dome in Ohio and thinking, oh, this must be Australia because no one wants to live here. But let me tell you one more time. This Emspire is the world. The world is resting on the back of the celestial turtle. This is why all these flat earthers are crazy, because everyone can see the earth is a semicircle. That's why you have the curvature when you look over the ocean. But as you can clearly see, this is America, and all the way over here is China. These are the highs and lows, these are mountains. There's no room down here under the legs of the turtle for Australia. The celestial turtle would step on it. This is science. And I don't know why Australians. I haven't been to Ohio. I don't know if it's so horrible that you have to make up a place to live. But the celestial turtle doesn't have any ground because it's only got the curvature on the top, and the Earth is a semicircle. This is science. You can't argue with science. John O'Keefe was not hit by a car. Australia doesn't exist. See, everyone knows it. Where's New Zealand? New Zealand is resting on the tail of the turtle. That's why they have a lot of earthquakes. Again, everything is just science. I don't know why people. Oh, I want to live in Australia. The turtle tail is New Zealand. Hey, Chris, happy Turkey Day to you as well. No, the Philippines is just above the tail. It's that little butt piece that sticks out on a turtle. That's where the Philippines are. They also have a lot of earthquakes because that's also why you have St. Andreas Fault. Stop blaming the Mexicans. Every time the turtle retracts its head, that's when you get the earthquakes in California. Again, there's a reason why I studied to be a school teacher. You sure they're not from the state next to Ohio, Oklahoma? It's Ohio, Oregon, Oklahoma. Sweden is located where? Hell. That's where Sweden is located. But I promised you all, well, I didn't promise you anything, but I said that we were going to look into the Alan Jackson California case. You might know that a young man drove like an idiot down a very dangerous piece of road in California and unalived, I believe it was 4 young women. Stupid, insane, should be kicked so hard in his bollows that that he will never ever do anything but sit down and pee because he's an idiot. But there's always a but because there's more assholes than cake in the world, and we all sit on one. The state charged him with, I believe, manslaughter in this case. And that's where Alan Jackson got in the case. Because normally every other car going down the same route, and this is a road where a lot of people have been killed because people drive like they have their head surgically implanted in their a-holes. Everyone else won't get charged like that. But all of a sudden, they decided to charge this young kid because apparently he came from a little bit of money and he had a nice car. And now we were out here to make a political statement. As I always say, the law is supposed to be blind. It shouldn't look at you and say, well, you're black, you're guilty, you're white, you're innocent. You're rich, you're guilty, you're poor, you're rich, you're guilty, you're poor, you're innocent. Should never, ever do that. Everyone should be treated equally under the law. Sadly, this case looks like it's gone absolutely cray-cray. And this is a hearing where I believe they are trying to reduce the bond amount that this kid was set to pay. AJ will be yelling a bit in it. So I think it's going to be interesting. That's not entirely true. 0.5 miles earlier, he was under the speed limit according to the data. His car was also clipped by another vehicle, and that's when speed increased. Well, let's go and see who it is. There was 4 girls killed. Yes, I know that. And to anyone who says, well, this kid is a sewer bit because he unalived 4 girls. With what I've seen so far, with his high speed, and I don't know what the circumstances were, if he was clipped or not clipped or whatever his explanation was, he ended 4 lives. You shouldn't do that. No matter if you have unless you have a really good explanation. But even though you might be a shithole, you still deserve to have a good defense. We don't believe on this channel that just because you are a horrible piece of crap that you don't deserve a defense, because it's in the American Constitution, the 4th, the 5th, the 14th Amendment, that guarantees everyone the same rights. And I think this guy is lucky that they could get Alan Jackson. I know a lot of people are, well, why is he defending him? That's his job. Most defense attorneys defend guilty people most of the time. Their job is to make sure their rights are not stepped on, that they will get a fair trial, and potentially maybe even get them some good deals because they can prove that the state didn't play fair. We want the best defense when we like people, but we should also maybe especially want it when we don't like people, because it's also a way to I say also a lot today. It's a way to make sure that future appeals will also be lessened, because they have had the optimal defense. I don't know if any of you watched Wanda's, that absolute insane lady who tortured her kid to death. She was in court the other day trying to get a new trial because she said she had ineffective counsel. And she's insane. But she still needs a good defense, because if she can prove that she had an ineffective counsel, then we're going to go all over again and we're going to drag everyone through it again. So better a good defense the first time. And if they're guilty, look it up. If they're innocent, thank you. Come again. But everyone should have the best defense. We have seen a lot of public defenders who probably do it of all the best reasons, but most of all, some of them are just phoning it in, and they shouldn't do that. Everyone should have the perfect defense. The good reason, it was an accident. Well, then you get into it. If he was above the speed limit, then if you are above the speed limit and you get into a car crash, your insurance company will not pay for your damages, because you broke the law. And when you break the law, you're liable to it yourself. You can't just put it on your insurance company, because they have a rule that you have to be within the law. An accident that you made happen by either drinking or driving too fast will still be counted against you. That's the problem. But this piece of road is known for excessive accidents, and should probably be first on the list for the city to do something. In Denmark, we have a lot of these like small islands where the road will be made smaller, so you have to go around it to try and keep the speed down. Probably get a few of those on this road. Do like in Le Mans when people started driving too fast, put some curves in it. I know Americans are not fond of roads that swerve, but it'll keep the speed down a bit. I think a lot of people speed. There is way too many cars on the roads these days. This is one of my biggest gripes I have with the idiot who lives with my daughter, because he drives like he's in a rally game. Apparently not when he got my grandson in the car, but he still does it. And I said, why? Well, it's fun. I said, yeah, really fun until you lose control of your vehicle and you slam into a car and kills a 2-year-old. Well, I haven't done it yet. Well, you have been in an accident because you hit a spot of black ice and totaled my daughter's car. I'm not a saint. I do drive too fast sometimes, but I have actually, since I got the speed cruise control, I just have it at the speed limit everywhere. If I drive faster and I get there 5 minutes before, what does it change? I'm always 10 minutes early anyway. I would just been 15 minutes early. That's one of my big gripes. Don't drive when you're impaired, and just get your lazy bum out of the house so you don't have to speed. It's not that hard. You just plan. You say, I have to be here in 2 hours. It'll take me 2 hours to drive there. Okay, I should have driven from home 20 minutes ago, so I had enough time if there was an accident on the way. It's not that bad. It's just about it's 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 kind of selfish when you think about it, because I have the right to do it and I'm a good driver. Yeah, just until you hit that school bus, you're the best driver in the world. Just follow the law. It's not that hard. How did you drive when you were 25? Last year, exactly the same way. I had an accident when I was 20 or 21, where I hit some black ice. I went over a ditch into over an embankment, into a ditch, into a tree, and since then I don't think I have. I've had one speeding ticket in my entire life. Yeah, yeah. Just get going earlier so you don't have to speed. Turn on the music. Well, I used to listen to audiobooks. That's what I do. Thank you, Spacey Stacy, for 14 months. Great advice. Well, it's riding in a car is a weapon. And you will, if it goes wrong, it goes really wrong. And thank you so much to Holly Mac for gifting 5 memberships to His Airness, Beth, Camper for Life, Sarah Cabot, and Sherry from Aussie, another Ohioan. Thank you so much, Holly Mac. I wish it would change color on these ones as well. It's a little annoying that it doesn't pop so I can see it, because I talk too much and don't see what's going on. I've only gotten one speeding ticket, but a few warnings. Never had a warning. Never ever had a warning. I've been stopped a lot because I drank way too much when I was a kid and started getting a fatty liver, or that's what you get when you're an alcoholic. And mine had started to go bad, so I had to stop drinking and give my liver some time to recuperate. And when you're not drinking, well, I can just drive my friends into town so they don't have to take a taxi. And I got stopped almost every weekend because I was in a car at 1 a.m. in the morning driving into town. But I've never blown positive. I have, sadly, I have done some. Well, I probably shouldn't have driven at that time, but I am very much against it, because I've lost some friends to it, and it's an avoidable accident. Let's get to this because I need to do a toiletry break as well. So let's watch this.
Member be present. Appearance, please.
Good morning, Your Honor. Alan Jackson with Jackie Speroni on behalf of Mr. Bohm, who is present in court out of custody.
David Marcos, along with Pauline Nazarian.
There he is.
Hello, Your Honor.
Hello.
Mr. Calandra, he's here. We'd ask the court to recall the bench warrant that was, or the body attachment that was held till today's day.
So, thank you.
Thank you.
Okay. The matter's here for hearing on the 995 motion that Mr. Jackson's Speroni filed, which I have read and considered, as well as the people's opposition and the defense reply. I read all of those several times, as well as the preliminary hearing transcript, and I have reviewed the exhibits for the preliminary hearing that were admitted into evidence as well. Who's going to handle the, Mr. Jackson going to handle it? Okay.
The 995, yes.
Yes, sorry, obviously I've read your written submission, but if you would like to add to it, this is your opportunity.
Thank you. Your Honor, thank you, first of all, for allowing us to be heard on this. I will try not to repeat myself. Obviously, the court has read our submission, we've read all the exhibits, the preliminary hearing transcript, but I think that there are certain issues that do bear on the court's ultimate determination, and I'm going to highlight those issues as best I can and as succinctly as I can. And it starts with one truth, a legal truth here in California. Speed cannot be treated as malice. Speed cannot be treated as malice. That is the rule in the state of California. It's not made up by the defense, not made up by me. It's not a tagline. It's the rule of law in California recited in a statement handed down to the lower courts by the Supreme Court Justice Kelly Evans. Your Honor, this case has always required one thing and one thing only from the prosecution, and that is proof of implied malice. Not proof of negligence, not proof of recklessness, not proof that this was a tragedy, which it clearly was. They must prove implied malice, and the law is crystal clear that implied malice has two separate and independent requirements: an objective requirement and a subjective requirement. The prosecution has never satisfied either of those, certainly not at the preliminary hearing. And I want to be very clear, right now, at least for the first part of my comments, I want to separate those two into different legal pillars. The first thing I want to address is the objective requirement. What act did Frazier Bohm commit that objectively involved a high probability that it would result in death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway, I could not be clearer about this, was a tragic collision. But tragedy does not equal murder. And the law does not permit the district attorney to convert a fatal accident into second-degree murder simply by calling speed malice. Because we go back to that first postulate, speed cannot be malice in California. Your Honor, there was no alcohol, no drugs, no texting, no racing, no distraction, no prior DUI by my client, no advisements, no Watson warnings, no statement of indifference after the fact, no criminal history, no driving history, no bad driving history, no serious consequences imposed by the government in a judicial proceeding. Nothing that has ever been cited in the cases where implied malice has been upheld in California. So what are the people left with? What are they left with? All of those no's, one after another, after another, after another, Judge, all of those no's make them rely on one thing, and one thing only, and this is the basis of their entire theoretical postulate. Speed. That's it. Alleged speed at that. Disputed speed. Undefined speed. And now, after apparently abandoning that exact theory, which is what they argued at the preliminary hearing, they want this court to treat speed alone as implied malice. And that is not the law. That brings us to the fundamental problem in their briefing and in the magistrate's ruling. The prosecution has misstated or did misstate at the preliminary hearing the legal standard, and the magistrate clearly accepted that incorrect standard. They collapsed the two prongs of implied malice into one, the two prongs being the objective and the subjective into one prong, and they continue to do so even as recently as their reply. The reply brief that we received this morning states, quote, "The objective and subjective determination of the lethality of speed." That is a direct quote from the prosecution's reply brief from this morning. They still are conflating and combining the objective and the subjective factors, and the law says you cannot do that. And they're doing it on the back of, quote, "the lethality of speed." They go on to say in their reply brief, in a two-page reply, in addition to speed, he also lost control of the car. Well, Judge, by definition, every crash involving speed is also going to include the loss of control of the vehicle. Otherwise, no crash. And then they throw in as almost a Hail Mary, and by the way, the defendant, quote, "was aware that he did not have full control of his vehicle prior to doing so," end quote. No citation, no quotation to the record, no citation to the transcript, nothing. Just a blatant, bald-faced statement with no foundation in fact. Where is the evidence? What evidence did they produce and present to the magistrate that my client, quote, "was aware that he did not have full control of his vehicle prior to doing so, prior to speeding, and prior to the collision"? There is none. They collapsed the two prongs of implied malice, as I just said, into one, and they applied pre-Reyes, and the court now is very...
No, this is just a hearing in I think it's called the Pepperdine Unalivings, is what they name it, or the Ritz Kit murder trial, or the four sorority girls killer case.
You're familiar with Reyes, the 2023 version of CalCrim 520, both of which, pre-Reyes and the prior CalCrim, do not control. They are no longer the law. And the prosecution got the law wrong. And they argued the law wrong. And the magistrate, unfortunately, got that law wrong. The California Supreme Court's current rule on the objective prong of implied malice is set forth in the new 520 CalCrim and the cases post-Reyes. Before we go any further into the facts, the record, the evidentiary defects that were at the preliminary hearing, we need to start with what the Supreme Court has already started for us, and that is the Reyes case. Because if this court applies the law as it exists today, which this court must do, not as it existed before 2023, then the murder counts cannot stand. They are legally infirm. Period. Full stop. The Supreme Court in Reyes made it unmistakably clear that to prove implied malice, the act itself must involve a high degree of probability, not possibility, probability, that it will result in death. That's not a risk, Your Honor. That's not a possibility. That's not dangerous in some...
Yeah, this is to take it down to manslaughter, because this kid has been charged with, I believe, second-degree murder, and they are arguing that there was no... he couldn't have known it would go wrong, that there was a probability that it would go wrong. There could be a possibility it would go wrong, but that takes it down to manslaughter. It's not murder. And this is what AJ is arguing, and he is he's quite fired up, it seems. spinning. If you're spinning, go out, come back in. It's probably a YouTube thing. I heard the family is not rich. That's what I heard as well. That it's because you live where rich people live, you must be rich. There's so many sides and appetizers we can munch on all day. I don't have any. I have a fruit bar, if anything.
Some generalized way, we can have possibilities and danger that still do not reach the level of implied malice. It must be a high probability of death, not just a probability. And that means significantly more likely than not.
Well, this is the same argument that people make in the Karen Reed case. Well, the other people were drinking too. Doesn't matter. Just because everyone else is breaking the law, it doesn't make it legal for you to break the law. That's not an argument to use that everyone else was robbing the bank. That doesn't make it legal for you to rob the bank.
I tried as I was preparing my arguments today to put this in terms that ring true to we lawyers and the community members at large as well. A high probability of death means it is significantly more likely than not just 51%.
Nikki, I believe you are in New England. I could probably be in New England, in the New England area, and go to the airport, get an air ticket. That'll be 2 hours. That'll be probably check in, check out. That's probably 3-4 hours. Then it's 8 o'clock. Then the flight, that'll be 8 hours. Then we are at 4 in the morning. Then I have to get out of the airport. That's probably another half to a full hour because of the immigrations. I could probably be at your house at 6 a.m. if everything goes well.
Not just more likely than not just the famous scales with a feather, significantly more likely than not, that you're going to kill someone when you commit that act. That you're going to kill someone when you commit the act. They rely on speeding. That's it. That's their entire theory. I've provided the court with 2 copies of the CalPRO. I just wanted to make sure that we're absolutely crystal clear about the language difference between those, the old and the new. They're marked. One copy is the CalPRO the people actually relied on. It was superseded and is no longer law. And one copy is the instruction post-Reyes, and that is the current law. In the old version, the objective standard, what I might have been arguing 10 years ago, before Reyes, highlights that, quote, implied malice requires an intentional act. The natural and probable consequences of the act were dangerous to human life. So be it. That's what the law used to be. But the correct law regarding the objective standard now reads as follows. The defendant has implied malice if he intentionally committed an act. The natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that it would, not may, it would result in death. The clearest language used by any court since Watson, defining a high degree of probability of death relating to traffic homicides, is the Moore case. The court explained in that case that Moore, Mr. Moore, the defendant in that case, drove 70 miles per hour on a neighborhood surface street, intentionally crossed into oncoming opposing traffic, causing other drivers to avoid him, intentionally ran through a red light at speed, struck a car in the intersection at speed without even attempting to apply his brakes, killed a passenger, and then evaded the police following that. And he did all of this, as he admitted, because of what he called, quote, wacky tobacco, end quote. That's a quote right out of the case, reasonably implying that he was high on marijuana at the time. The court in that case defined a high probability of death, and this is important, as a near certainty. A near certainty that the act would result in death. That's what a high probability of death means in California. Not that the act possibly could cause death, not that the act probably would cause death, not that the act was dangerous or even highly dangerous. but rather that it's a near certainty that the act alone would cause death. Did the people say or establish in any way at the preliminary hearing that the mere act of speeding on PCH, that's
No, there's been nothing done, and this is, I believe, it's one of the, if not the road with most fatalities in America, and they don't do anything about it.
what their postulate is? The mere act of speeding on PCH.
When did this trial start? It hasn't started. This is a pre-trial hearing where they are trying to change this. I believe it's second-degree murder charges to manslaughter charges. It's from last. It's a couple of weeks old, this hearing, but not a lot of people saw it. So I thought let's see what it's all about, because I've only seen a few reports on it. There's another case with the same prosector. The guy drove on the pavement sidewalks, went through red lights, killing 2 people and injuring 4, was charged with manslaughter. And this is the problem, because this kid did something and broke the law. No one is arguing he didn't do that. The problem is he's overcharged.
Is nearly certain to cause death. That is absurd. They did not, because they cannot. It is objectively not true that speeding on PCH nearly always causes death. In fact, it does not, and the people well know it. So that objective factor and the act claimed by the people as a high probability of causing death has simply not been met. It wasn't met at the preliminary hearing. Therefore, there is no implied malice to prove this case or to prove those charges. That is the controlling law in California, and it's simply not the standard that the prosecution applied, and it's not the standard that the magistrate applied, respectfully. The prosecution argued at the preliminary hearing what the magistrate ultimately accepted is the old formulation, that an act is sufficient to satisfy the objective requirement if it's dangerous to human life. And again, if we were standing here arguing this in 2015 or in 2022 before Reyes, I might not even be making this argument. But here we are in 2025, post-Reyes, and that's no longer the law. Danger is no longer enough. The Supreme Court expressly rejected that diluted standard and replaced it with a far, far more narrow standard. And that matters in this case. This is that type of case where the law actually makes a difference. The law actually defines what this court can and should do. Because failing the objective prong just ends the inquiry. We're just done. If the act does not objectively involve a high probability of death, there is no implied malice, even if the defendant was fully aware of the risk. And in this case, he wasn't, which I'll get to in just a second. The Supreme Court Justice that I referred to earlier, Justice Evans, has already anticipated and warned against the exact mistake that the people are making in this case. She literally saw it coming. The exact.
I love that Fedorowski says stuff like this. I don't know what a high pass filter is. I don't know if I could use it if I found one. I will probably be trying to look into how to use the OBS thingy that gives you a few more options, but I don't know if I can, because I know that Recovery Addict can do something with the sound from court, but I'm an idiot. If I need to push more than 2 buttons, I will probably start a nuclear reaction.
Arguments that they're making and warned the lower courts against that argument. In a published statement following Reyes, Supreme Court Justice Evans explained that lower courts in vehicular cases have been ignoring the objective standard, applying an outdated.
Andriel, in Denmark, the first year you have your license, you have to have someone over the age of 25 seated next to you who cannot be under the influence of anything. So that's how my kids had it, and their cars they bought themselves. Cars are insanely expensive in Denmark because we have 180 168% tax on them. So normally you'll get into a clunker to start with. My daughters both started out with a Fiat 500, shitty little shoebox box car, but that was the car that every young girl had at that time. And we normally say, well, if you want a car, you can buy it. But normally when you're past 18, you'll let your kids drive your car. But the first year they have to have an experienced driver next to them.
CalCrim language and treating speed as if it were inherently sufficient to show implied malice. It doesn't get much clearer than that. She stated plainly, quote, and this is her quote, not mine, quote, speeding, even at a high rate, does not automatically equate to a high probability of death, end quote. That is not my characterization. That is a sitting California Supreme Court justice explaining that in vehicular cases, you must apply the Reyes standard, and failing to do so is reversible error. The fact is the people in their entire opposition relied on and stated the wrong law, and the magistrate got the law wrong as well. Justice Evans explained why that outdated law was changed. Why was it changed in the first place? Why even address it? She explained that thousands of Californians drive at excessive speeds every day without causing death. As the justice noted, just as drunk driving does not always, or even usually, result in death, neither does speeding. That means speeding, even extreme speeding, cannot be treated as malice per se, which is what the people are asking this court to do, and what they asked the magistrate to do. There must be evidence that the act in the circumstances, the actual act in the circumstances presented, had a high probability of actually causing death. And here there is none. Not one witness, not one expert, not one data point, not a study, not one.
Yeah, I know that the norm is 16 in the States, which I always found was a little bit redonkulous, because you can't drink at that age. So when you hit 21 and you have been a driver for 5 years and you start drinking, you don't know what drink does to your body, and you'll probably get into some DUI situations because of that. In Denmark, you start at the proper age drinking when you're 12, 13 years old. So you know when you have had too much to drink and don't drive. So I think it's better the other way around, that you learn all the bad stuff before you get a car.
Foundation of evidence that driving at X speed for X number of seconds has a high probability of killing someone. But people didn't even try to make that showing because they cannot. They relied instead on outdated pre-Reyes jury instruction, and the Supreme Court's already said that's manifest error. And as Justice Evans said, I just indicated, she warned courts, don't do this. Do not do this. The people are asking this court to do exactly that. If this court applies the law as it currently exists, as I've discussed it, post-Reyes, the murder counts have to be dismissed. Now we have the correct legal frame. I want to return back to the prosecution's theory, the one that they propounded at the preliminary hearing, the one that they relied on in their opposition papers.
No, you have to be 16 to buy beer. No. Yeah. No. I don't know. I'm 27. I when I was a kid, you could buy cigarettes and hard liquor at any age. But I think the rule is now you have to be 15 or 16 to buy beer and wine and stuff like that. And you have to be, maybe you have to be 18 to buy hard liquor. Maybe I should look it up. But no. We have gone woke as well. Can't start drinking at 12 years old. What's happened to the world? Well, it's because you can't handle your drink in Norway. Here you can drive a moped at 15, get a roller license at 16, drive a car with a designated adult at 17 and a loan at 18. Aside from the moped, you need licenses, therefore go to driver school. In Denmark, you will need a moped license as well, that I think you can get when you're 14, 13, 14 or something. We could take it at school.
At the preliminary hearing, the prosecution's argument was there has to be a number where speed becomes murder. There has to be a number
No, I didn't start drinking until I was 12 years old, I think.
where speed becomes, it's undefined. There just has to be one, Your Honor, where speed becomes murder. That was their theory then. They told the magistrate that speed itself was both the objective and the subjective proof of implied malice, and even in their reply papers, they do the same thing today. Objective and subjective determination of the lethality of speed. They're still continuing to make the same legal error. That's not the law. There is no magic number at which speed automatically becomes murder. The law doesn't permit implied malice to be inferred from some undefined mileage per hour or even a defined mileage per hour. And the Supreme Court in Reyes and after Reyes has explicitly warned courts not to collapse those two objective and subjective standards or prongs into one single fact, like, for instance, speed. In the opposition, the people have abandoned their original argument. They've tried to replace it with something even more legally deficient. The idea that Frazier's general familiarity with the phrase, quote, speed kills, that slogan, proves both knowledge and conscious disregard. Because once he heard the slogan, or because one time he may have heard the slogan or saw it somewhere on the side of a bus or a bus bench. That is not proof of subjective malice. That is proof that the defendant is a human being who's seen the same public safety billboards that you and I have seen and the rest of us, everybody in the audience have seen and are familiar with. Think about it. If this court, Your Honor, were to uphold the people's improper theory, every time there's a vehicular fatality, pretty much every time, all the officer would need to do is say, have you heard that speed kills? And if the unsuspecting driver says yes, now they're facing murder charges? Implied malice requires the defendant to have actually appreciated the specific danger of his or her act at that time. Not a general awareness that speeding somewhere, sometime, somehow may be dangerous. The requirement is this. I know the act is nearly certain to kill someone, and I'm going to do it anyway. That's the standard as set out by the Supreme Court. I know the act I'm about to engage in is nearly certain to kill someone. I'm going to do it anyway. That's implied malice. That's the subjective factor. Nothing in the record comes close to that standard, Your Honor, and the people know that, which is why they're trying to replace evidence with inference and slogans like speed kills. The people also want to rest on the fact that Frazier knew friends who died in an automobile accident at some point in his past. They want to suggest that that's enough for his subjective intent to consciously disregard the near certainty that speed can kill someone. Your Honor, we all likely know someone tragically who has passed in some sort of traffic accident. I'll bet if I asked for a showing of hands in this courtroom, very few wouldn't go up if I said, do you know someone or know someone who knew someone who tragically passed in a traffic accident? But under the law, that's not the same as being sensitized to the consequences of certain acts. That's what the law requires. We have yet to find any case in all our research in which that was the predicate for the subjective requirement. And yet every case that we have found, including Ortiz, which we cited, states the opposite. The subjective requirement can be established only from suffering serious consequences from the government because of your own conduct. That's Watson. This court knows that case inside and out. That's Watson. The defendant had suffered sanctions by the government, warnings by the government in judicial proceedings, in a judicial governmental environment that warned him against the very act he then went out and did again. That is missing here. The people cannot replace Frazier's subjective knowledge with a traffic slogan and somebody else's traffic collision. That's not the law. The court has never done it, and I seriously doubt that this court wants to be the first. Thus, the prosecution cannot satisfy the subjective component either of murder or implied malice. There's no evidence, none, that Frazier Bohm believed he was actually traveling at 100 miles an hour, 90 miles an hour, or 80 miles an hour. There's no evidence of that in the record whatsoever. The unrefuted evidence of what was subjectively in Frazier's mind is, the court read the transcript, I don't know, I don't know, I don't know, when asked over and over and over, how fast were you going? He said, I don't know. If Frazier did not know his speed, then clearly he could not have consciously disregarded a danger he didn't perceive. The Supreme Court has repeatedly said, you can't disregard a fact you don't know. Further, unlike in the Moore case, which I cited to the court a little bit earlier, and Gonzalez, which is in our papers, where the defendants admitted that they knew that what they were doing had a high probability of death, and they didn't care. They knew exactly what they were doing in both of those cases. The defendants in both of those cases said, I don't care. There's no evidence that Frazier knew what he was doing, was, quote, nearly certain, end quote, to kill anyone, a high probability of death.
Nobody wears a sign around their neck saying, my intent is to do this. My knowledge is so-and-so. It has to be judged by their actions and by the totality of the circumstances, doesn't it? Nobody comes out and says, my intention is to kill somebody when they point a gun at someone. My intention is to kill you. Nobody says that. You have to base your judgment as to what their intent was and their knowledge on their actions and on the circumstances surrounding it, don't you?
Circumstantial evidence has to be used to a certain degree. Absolutely, I agree with that. Nobody wears the sign around their neck saying, I intend to do this. But in every case in which that subjective knowledge has been imputed to a defendant, in every case, Ortiz, Gonzalez, Moore, all those cases have evidence in the record that the defendant knew what he was doing, had a high probability of death, and then ignored it, intentionally ignored it, through his statements, through his conduct after the fact, through fleeing after the fact, trying to avoid prosecution after the fact, saying, I knew I was going to go through the intersection. In Moore, for God's sake, the man drove through an intersection, killed a pedestrian, drove home, then said...
Are we talking about Chris Albert? Wasn't that what Chris Albert did?
When the officer said, well, you know what you did, didn't you? And he said, yeah, I think I cut the guy in half. It was disgusting. And there was subsequent post-conduct comments by all of those defendants to suggest they knew what they were doing and didn't care about it. That's the inferential evidence that was used in those cases, and that's what I'm highlighting to the court that we don't have with Frazier. He didn't know how fast he was going. He did not have that information.
That post-accident conduct, as disgusting as it was a factor, but it wasn't in and of itself determinative.
It was a factor that they used in addition to the other factors to indicate inferentially that they knew that their conduct, that speeding on surface streets, high rate of speed, going through an intersection, etc., was inherently dangerous to a point that it was in that, as the jury instruction says, in that there was a high probability of causing death. That's what's missing, Your Honor. The court is exactly right in highlighting this. Of course, no one's going to wear a sign or send a voicemail saying, I know what I'm about to do is nearly certain to cause death. The problem with the prosecution's case and the magistrate's holding order is that there's no evidence. The record is completely deplete of evidence.
I think it's his style. He's very assertive in his style. I think that's why he and Cannoni didn't gel that well. But I also think that it might work for judges who might be a little fence sitting. You know, people who don't really, who's not that sure of the law. If he says you must, And again, it's a style. I think some judges will get pissed off by it, saying, "Hey, it's my job. You better shut up." And other judges might do the opposite and say, "Oh, I must." So I think it's a style. I think that's what you could see with the big diversity in the Reed team. You had the nerd, the Alessi type who had all the details. You had the Yannetti who was more like, "Oh yeah, sure, we're going to talk about it and let's find out, judge." And then you had the AJ that's more duke it out kind of type. And it's a style every lawyer has. You also have that. If you watch the Sarah Boone, you had the "I just come in from the small town to the big city, and you all been so kind in here to take care of me. And oh, I'm just a small county lawyer. I don't know them big laws and stuff, but please don't hold that against my client." Every lawyer has their own style. Hey, Kimber's from Ohio, which is next to Australia. What happened to AJ's hand? Boating accident. I don't know. Happy Thanksgiving to you as well, Sleuthy. And if you are of the Delphi persuasion, I didn't cover that case. I only talked to Mo, who was into it a lot. Sleuthy is doing a lot of good work. If you want to go check out all the nitty gritty, and if it's Sleuthy, it's gonna be well researched. So go check that out. He burned it. Let's just call it a boating accident. That's more cool.
That Frazier knew how fast he was going. That's why I brought up his.
I didn't watch much of the trial. I talked to Mo because she's local to the area. If you don't know Mo in the Deep End, one of my favorite creators on the YouTube, she helped me cover the Karen Reed stuff, and she lives close by, and she said it was a hard one to get through. She went to the side of it, and yeah, that was a weird case, and there's something very wrong with the Richard Allen as the guilty person in that trial. As again, I have the helicopter view, but it seems like it's another pin it on the girl just with a guy. That there was a lot of things they didn't look at. Some male fluids on the victims, some phone records, and it just seemed. Go watch Sleuthy Goosey and her amazing coverage of it. If you don't know the Delphi case, you need to know the Delphi case. And you don't get much more in-depth coverage than you do over on their channel. So go check that out. I was on fire once. It was not a good time. I do not recommend. Being on fire sounds fun, but it's not. It's not what you want to go do. Trial wasn't allowed to be televised, but we have transcripts now. Yeah, that's another thing. Again, like I said in the beginning of the show, you might have been basting your turkey. That's not a euphemism, or having smacks. But I talked about the McAlberts pushing it up to the federal court. When you take away the public eye, you will get all kind of crazy stories out there, and it's probably not good for you. And I think this is one of the things why Delphi has a lasting legacy is no one really knew. You had Andrea Burkhardt, who was in court and had a lot of insights, and now you have the transcripts, but there was a lot of shenanigans going on. And whenever you don't show the public what you're doing, the public will speculate, and it will backfire. Mo has two gorgeous friends. I'm just now heading out to a 4.5 hour drive. Then you will be there at around 3 o'clock. Whew. We just did a live with Andrea on Criminality TV channel like 2 nights ago, I believe. Yeah, I saw you had her on, and what an amazing. You have that weird brain for finding all the facts, and she has the same thing, and she is so knowledgeable. I'm just a hack. I just steal your homework and then I pretend I know stuff. But you know when you talk to her, especially about that case, that was personal for her. There's something that really triggered her on that case. So you have to go to Criminality TV's YouTube channel and watch it because it's really good coverage. I can hardly no, that's not. I can really recommend it. The other one sounds like I don't recommend it. We are Italian. We eat early. Well, starting at 2 and then go till like 8, 9 o'clock. That's a good feast. DDP was there too. Diamond Dallas Page. What? What did I miss? Who saw Diamond Dallas Page? Hey, the other Mary B. Where the hell did that go? Hellfish Haven. Yes, Hellfish Haven for 7 months. Gobbledygooker's greatest turkey gift from the WWF. Who was it who played the Gobbledygooker? It was it Terry Taylor? No, he was the Red Rooster. That was a shitty pay-per-view. Defense Diaries podcast. That's not DDP. DDP is Diamond Dallas Page. Bang! The People's Champion in WCW and one of probably the best people that most people don't know all the good work he does. He's a former wrestler who have made his own yoga program. That's yoga and calisthenics. I used to do it because I needed to get back to moving with my back. And he has helped a lot of people, especially former wrestlers who have been Razor Ramon and Jake the Snake. Both of them were heavily addicted to drugs and alcohol, and they would just beat up because wrestling, even though it's fake, gravity is real. So all of these bodies are just banged up, and he put them up on his bill. Of course, he did a documentary, so it's not for nothing, but he put them up in his house. He made them move again. Scott Hall got to get back in a pretty decent shape. He could hardly walk, and he got him back. He got inducted into the WWE Hall of Fame, got clean, got to spend some good time, and sadly passed away a few years ago. And Jake the Snake Roberts, who lived a really rough life. He got him clean and got him smiling again. And the latest two people is Buff Bagwell and Lex Luger, who he also helped treat. Most of you don't know who I'm talking about. If there's a wrestling fan from the 90s, you know exactly who I'm talking about. Lex Luger got inducted in the Hall of Fame, I think, last year, maybe the year before. He was paralyzed after some strokes. By the grace of God, he had a stroke and would have passed away, but Diamond Dallas Page was at his house that day to talk to him because he just had an inkling saying, I need to go talk to him. Then he would have passed away if he wasn't there to call the ambulance. So it's that guy is doing a lot of good work with a lot of people who have had a hard life. So DDP will be Diamond Dallas Page, not Defense Diaries podcast. Defense Diaries podcast will still be Defense Diaries podcast. Also, an amazing podcast that you need to follow. They were reading the Aaron Spencer documents yesterday. The kid has found them for me, but it seems like there's a geolog, so I can't log into that website where it is. I really want to follow the Aaron Spencer case as well, because that's another absolutely crazy case. I saw a snippet where the Motters was talking about they misplaced the dash cam memory card that could have shown what happened, but it got knocked out of the camera when the police officer turned it in. Sure it did, Jen. Sure. Sounds like an amazing person, to be honest. I love a little less blah blah, a little more action. He is a good, yeah. I don't know Lex Luthor, but I know Stone Cold Steve Austin era. That's because Lex Luthor was just before him. Lex Luger, not Luthor. Lex Luger was just before him. He was supposed to be the next big thing after Hulk Hogan. Didn't work out because he has the charisma of a wet sock. So he went down to Atlanta and started for WCW. So if you watch the Stone Cold era, you were a WWF fan, not a WCW fan. It was Hector Guerrero who played the Gobbledygooker. That was such a shitty gimmick. DDP is a much better actor than The Rock. That's because The Rock has to play The Rock. DDP plays the role he's given. My Sicilian Thanksgiving lasts all day. My uncle bakes all the best Italian food, and there's turkey for the white people. I like Bob Mata. I like both of them. I don't know. I don't pick favorites. I really like that show, and he was gracious enough to join me once, and I'm thankful for that. Yeah, funny how exculpatory evidence go missing a lot. It just happens. It's never that crucial evidence that the state needs to prove you're guilty. It's always the thing that might point to the state doing the wrong decision. Isn't it funny how it happens? Lex killed Miss Elizabeth. Well, they were doing drugs together at least, and then she passed away. But yeah, he I don't think it was kind of like Superfly Jimmy Snuka, but he wasn't a good guy. I'm friends with Maverick Wild. Does that count? Lost to all the greats. If you are good enough to be a jobber who can work with the big names, yeah, that counts in my book. You have to be trusted to work with those guys.
How is somebody driving 100 miles an hour or 90 or whatever the speed actually was up in that range not know that you're going super fast? How would you not know that? Realistically.
Super fast is not the standard.
No. But answer my question. If you're driving a car 95 miles an hour, you know you're not driving 40. Am I wrong about that?
You're not wrong about that. But speed alone is not.
I understand that.
Speed alone is not. It's not enough.
But to gauge a person's knowledge of what it is that they're doing, the consciousness of it, you have to use common sense as well. And I'm sorry, when you're driving 95 miles an hour, 100 miles an hour, you know you're driving extremely fast. You know that.
If other cars are driving 70, 75, 80 on Pacific Coast Highway, which, Your Honor, they do all the time. I mean, now we're just talking about perception, right? Now we're talking about the court's perception. You must perceive that you're going fast. I was on that road 2 weeks ago. There were sports cars passing me. I was going 70. By the way, that was above the speed limit. Didn't realize it because every car next to me was either going the same speed or going faster than me. It's a perception issue. It's not like he was going 70 or 80 or 90 miles.
I'm sorry, that's a shitty argument. You have the obligation to make sure you're not breaking the law. Just because everyone else is breaking the law, you can't use that. Well, it's a perception. No, every car, and I think this is a legal issue, every car must be equipped with a speedometer. That speedometer, this is my easy way to not get speeding tickets. I will teach you it right now. Most roads will have a sign on the side that says a number. If you take that number and then look at your speedometer and it's below or at that number, you will never ever get a speeding ticket. It's a magical trick I found out because we have some big red and white signs with a number on it. And if you look at your speedometer and it's not above that number, you are not going too fast. Just because there's a car going past you, it doesn't mean that, oh, my speedometer must be wrong. I can't go faster. So even though you are perceiving your speed to be lower, you have an obligation to follow the law. I'm sorry, this is a bad argument.
Miles an hour, whatever the speed is, which the prosecution cannot define in a 25-mile-an-hour zone right next to a school. He's on PCH. And other cars are going similar speeds. Yes, he may have been going faster than the cars next to him,
Yes.
but not to a degree that it's a near certainty to cause death. And that's the point at which it would have to be.
I'm going to discuss the testimony of the prelim and what the underlying facts of the case are, but just as a preview, all of the evidence from the civilian witnesses in the case was that the defendant zoomed away far faster. They couldn't even come close to saying with him he was driving so fast. He was hundreds of yards ahead at the time of the crash.
The witnesses, not a single witness at the preliminary hearing put him going 100 miles an hour. Not a single one. As a matter of fact, the witnesses that were asked how fast do you think he was going, they estimated him going around 70. That was in the preliminary hearing transcript. I'm not there. That's what they said. That is not extraordinary, and certainly that's not enough to suggest a near certainty that someone is going to die. It's just not enough. I'm not saying, and I don't want to get spun into a discussion or even an argument certainly with the court about, was it dangerous? We can all agree, speeding is dangerous. We can all agree that it has a possibility of causing.
Yeah, I know what he's arguing, but it's just a bad argument. Because just because everyone else was jumping off of that bridge, should you be jumping off of that bridge? It's your obligation to ride at the legal limit. So just because you think, well, all the other guys can do it, I can do it too. That's not the law. That's exactly why I call this a bad argument. He is arguing that you can break the law because others are breaking the law. No, he should be aware, especially driving a couple of 1,000-pound vehicle, what his speed is at any given time. That is an obligation that you are taught when you get your driver's license, because the law is the law. Just because everyone else, and I know it, you go on the freeway and you go for a little bit and you start listening to some sweet Tay-Tay tunes and you sing along. And then all of a sudden you got the heavy foot because the one in front of you is going 140 and you go 140. But just because the other car broke the law, you are not allowed to break it. You will get the fine. And if your argument is, well, all the other people were also going faster, the police officer will look at you and say, but I stopped you. That's just, again, it's like the Karen Reed argument. Well, everyone else was drinking. Yeah, but she was the only one charged. It doesn't change it. Exactly. That's the same thing I do. I have it at just above, because in Denmark, they have to give you 3 kilometers rebate on it. So I go just above the speed limit, set it for that one, and then I'll just stay on that one. Yes. But he is using the argument everyone else was driving fast, and this is why my client was driving fast. And that's a bad argument. Again, all my friends was robbing the bank, so I thought it was okay to rob the bank. It's not an argument you can use in the court. I think there's way better arguments that I would bring in how many other people has rammed into people and never been charged with second-degree murder. That this is clearly a political decision to charge this guy because the demographic fits. This is a rich white kid, so let's get him down for murder. And that's my problem with this case. My problem with his argument is just it's a null and void argument. Everyone else was doing it. It's not a good argument. His argument should be every single other person who have done exactly the same has never been charged in the same degree. And that's wrong. This is clearly a political decision by the pro sector because they wanted to look tough for the next election. Hey, Stylen, how are you doing? A thought just hit me. Those who said they've never been in an accident that was their fault, how many of them are lying? Probably half of them. How many who has been caught in a DUI and said they had 2 beers lied? All of them.
Death or great bodily injury. We can all agree with that. That's not the law.
Can we agree that the faster you're going, the more likely it is to cause death?
Depends on how fast you're going. Absolutely depends on how fast you're going. We can all agree on this. According to Justice Evans, that's not enough.
Right.
That is not enough by itself. And that's the only thing the prosecution has. Speeding. That's it. And that's notable. The people routinely charge vehicular manslaughter, not murder, just as the court is discussing, in fatal speeding cases, unless there's clear evidence of the subjective knowledge. 2 weeks ago, to that point, to the court's point, 2 weeks ago, maybe not 2 weeks ago today, maybe it's 14 days, 15 days, 13 days ago. It was October 25th. This same office filed manslaughter charges in a case called People versus Kirksey. The driver was speeding on surface streets, drove onto the sidewalk, struck and killed 2 pedestrians, severely injured 2 others, then fled the scene, then fled the jurisdiction. He was finally caught in Chicago 2 weeks ago. Killed 2 pedestrians, injured 2 others, fled the jurisdiction,
And I can't get tiplets in my DMs, but apparently if you are near Buck, you can get titlets in real life. Insane.
and fled for the specific purpose of avoiding prosecution. Manslaughter. They didn't even approach murder charges in that case. If the law is anything, it's got to be deliberate.
Going at the speed limit on certain highways in the US, around Boston, for example, will get you pulled over by the Massachusetts State Police. I was told when I was in Delaware and we drove to Washington, we were out one night going to see the police station where my friend works, and her husband was driving like a maniac down this country road, and I said, "Aren't you going a bit fast?" He was going like 70 on the back roads. I was like, "Oh my God, I thought 55 was the speed limit, which I think is insanely low. You should get some higher speed limits." But he said, "Nah, everyone does it." And I said, "Well, the problem is I'm driving on a Danish driver's license. I'm driving in a rental. I'm going to use this cruise control. And when the GPS says this is a 35 mile per hour, I'm going to drive 35. I'm going to drive 55. I'm going to drive 60, whatever I'm allowed to do. Because they would love to pull someone over like me and give me a fine. So I'm not gonna speed, especially in a rental in a foreign country. That's so I would probably be pulled over if I ever go to Boston, but I would also get a fine because I would be under the legal limit, and you can't be under the legal limit driving anywhere in Massachusetts, is what I've been told.
Frazier, by contrast, as established in the facts of the preliminary hearing, stayed at the scene, cooperated with investigators, no drugs, no alcohol on board, no driving history, no fleeing, no secondary criminal act, all of which this other case had. Like I said, if the law is anything, it has to be deliberated, and it has to be consistent. And that means that similar facts should produce similar charges. And less aggravated facts should never be charged more severely. Selective charging is not just unfair, judges, this court knows, it's unconstitutional. Here, there's not even evidence that Frazier intended to drive fast for its own sake. Every available piece of evidence supports the opposite, that he was reacting to events unfolding in the moment, including being chased, being clipped by another vehicle seconds before impact. That is not malice. I'm not arguing that it wasn't dangerous. That's not the law. The law is for malice. It has to be a near certainty to cause.
Are we going to get more trailer trash bits? I don't think she's really worth it anymore because she's just an idiot. She's sitting there, she's fat, she's lonely, and she's sitting in her pink chair begging money for a party bus. At some point, it's kind of like going and signing up for the Special Olympics when you don't have a disability. It's not fun beating a crippled person, and she is she's crippled in her head because she has no brain. And again, I don't want to fight her over the fucking copyright strikes that she's going to use against me because she's a whiny little C word. And I hope I can find something and make fun of that. I did get a picture the other day where she had her big birthday bash with 37 viewers, but I need something good, and then I'll put on the wig again. But the wig is only for special occasions.
Death, and he has to subjectively say, I know it, and I don't care. That's their burden. What we have before us is instinct, not intent, not subjective intent. This was not malice. This was an accident. Perhaps negligence, not murder. The people now argue in their papers that the cause of the crash, astonishingly, is irrelevant. That doesn't change his culpability. Let me say that again. The cause of the crash is irrelevant. Your Honor, this is a murder case. Causation is everything. If Frazier was clipped or swerved or reacted to external events, that his act was not the probable cause of death. That alone defeats the murder charge. And the people's own exhibits show driver's side contact with his car, white paint transfer, matching the damage to Ms. Ortiz's vehicle. The very facts that the prosecution sort of wants to pretend doesn't exist.
I don't know what Alice's restaurant is, but keep those traditions going. It's nice to have traditions. We didn't really have a lot of them, other than my dad was never home at Christmas.
Cannot argue implied malice when the defendant's conduct was reactive rather than intentional. Your Honor, Section 995 exists for exactly this reason, to purge charges that sound gray or rest on legally unsupported theories. The Supreme Court has repeatedly instructed that 995 motions must be granted when the magistrate applied the wrong legal standard, not just where the evidence is weak, but where the governing law and the governing elements were misapplied. And that's what happened in this case. It's precisely what happened here. Judge Edward did not get the law right. He accepted the people's there must be a number, there must be a speed theory, and that's legal error. The people continue to cite to the court outdated law, and that is legal error. The controlling standard for the objective requirement has never been met, and that's legal error. Once the right law is applied, the outcome is no longer discretionary for this court. It's not even close. It's not debatable. It's mandatory. If Reyes governs, and Reyes does, I think we're all in agreement, including Mr. Parsons, that Reyes now governs. If the current CalCrim 520, which I placed on the court's bench, governs, and I think, again, we're all in agreement that it does govern, then the murder counts must be dismissed. The case comes down to this, and I'll close my closing comments are these. There's one unavoidable question. Did the prosecution present evidence that Frazier Bohm committed an act involving a high probability of death at the time, that he knew it, and that he intentionally disregarded it? The answer is no. Not a little bit, not barely, not depending on how you look at it. The answer is just no. No intoxication, no racing, no texts, no statements of indifference, no prior warnings, no subjective awareness, no prior serious consequences by the government, no bad driving in his history, ever, and no objective showing of a high probability of death.
Do the turtles gobble in Danish? Turkeys are not that common Turkey's, even though Turkey is a country, people from Turkey, and we have a lot of them. They used to come up here and do our work in the 60s. But we don't have turkeys. Turkeys is a native bird to the North Americas, and so we don't know them. We don't know what they say. We will chase pheasants and duck and maybe some geese, but it's most duck hunting and pheasant hunting that we do here. We don't have turkeys. That it's not common to eat turkey either, and probably for the right reason, because turkey kind of is the valley girl of meat. It's bland and boring, and they say like a lot. And just like a turkey, a valley girl probably would drown if she looked up in a rainstorm.
To a near certainty. Just speed. And speed is not malice. Section 995 is that safety valve, the safety valve that every member of the community relies on. It prevents.
You're getting an M-Spire even though you're not M-Spire. I want to make a turducken. Again, that's one of those things where you're why? It's very popular here to grill a chicken with a can of beer up its ass, and I don't know why. I don't grill a lot, so I don't know why it's good, but that's the thing. Do I hunt? No, I don't like killing living things. I kind of got enough of it in my early 20s. I've never hunted and done stuff like that, but I never had any problems if you had to go out and fish and take care of a fish and that. But ever since I got home from my deployment, I don't like killing fish. I don't like shooting at living things. I got enough of it. I saw enough blood that I don't want to see anymore. That's also why I don't like slasher movies and stuff like that. I've seen what I need to see, and I'm happy that other people will carve it up for me, that I don't have to do it. So I don't do any of that. And getting a hunting license and all of that, finding somewhere you could hunt would also be a big problem, because again, Denmark is one of the most agricultural areas in the world. So you have to rent somewhere to go hunt, have a license, and there's a lot of crap. And I never really felt the need to go shoot animals after I was taught how to shoot people, and I just don't. Nowadays, I just don't want to do it. I've seen enough stuff that I don't want to see it again. I go to the butcher shop and buy my meat, because then someone else have had to take care of it. It sort of keeps the chicken moist and flavors the bird with whatever ale you have in the can. So you open the can, because I thought you just stuffed a beer can in the ass of the bird, and I thought that's weird. But if you open it so it can kind of seep out and the vapors can moisten the meat, that makes more sense. Because if you're going in that hole, remember, moisture is important. Stop it. Stop it. You made me say that. That was a very valid truth journey. Well, I don't know if it's a journey, but that's just how it is. Well, I don't know. Again, I don't grill. Burning aluminum is a bad idea. Yeah. Yes, someone did say moist. It was Jamie. I don't know. In the South, we call it beer butt chicken. I never, again, I'm not big into barbecuing or grilling or whatever you call it. In Denmark, you would call it grilling. I've never really been into it. I think it takes too long, and it's just you have to sit there and it tastes like charcoal. Give me a steak. Well, I don't mind a sausage on the grill and then some salad. I like that in the summertime. But yeah, it's like if you don't poke hole in your baked potato, but you cut your baked potato down the middle. You give that a like a cross section so you can open it and put in the butter. You can also brine your bird. That makes the turkey and chicken very, very moist. Oh my. I do like a moist bird. The British people will understand that one. Can you bake a sourdough scored in the shape of a turkey? Sourdoughs are normally very soft, so it'll be a little hard to shape it. But you probably could. Emspire. I heard my name. Why did the turkey join the band? Because it had drumsticks. Thank you, Emspire, for showing all the other posers what a real bad dad joke is. This is what it is. I like ostrich. Sometimes it gets a little too gamey, but I like ostrich. It was really big back in the early 2000s. We had some ostrich farms in Denmark, and we went. My ex-wife, her parents had a farm, not with ostriches. They had beef and pig, potbelly pig. Great salamis you can make out of them, but. They had an ostrich farm not that far from it. So every time we went up and visited her parents, if there was a good sale going on at that ostrich farm, we would stop by and get some ostrich meat. I really liked it. Sometimes it could get a little gamey, but I really like ostrich. It tastes really good, I think. Yeah, they're kept as pets here as well, but it's a pig. Pig needs to be eaten. That's why pigs. God wouldn't have made pigs if it wasn't to be eaten. Why are they dressed in bacon if it's not to be eaten? Again, this is just science. I told you about the celestial turtle and the science behind pigs. They're made of bacon. That's why we need to eat them. Pigs on a spit is yum. Yeah, we got that for my was it my brother's wedding or one of the kids' baptism? When they do it right, it's good. If you get a pig that's too fatty and it's not cooked all the way through, it's really nasty.
Exactly this kind of overreach. And a law demands that the murder counts be dismissed so that this case can proceed on the proper charges. The charges the evidence actually supports. Manslaughter, not murder. We ask the court to dismiss counts 1 through 4 on those reasons.
Jackson, thank you.
Thank you. The defense rightly points out the change in Calprin 520, including the language of high probability that that was the result. But they just ask a question if the people presented that at preliminary hearing.
Why does he look like he reenacts Civil War battles on the weekend?
Well, it appears that the judge who held the defendant to answer believed so, when in his holding he said, quote, implied malice requires that the defendant act with a wanton disregard of a high probability of death. That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15. The committing magistrate clearly understood the law and apply the law to the facts that he heard. And we're here for a 995 motion. And the question then is, were there sufficient acts for him to draw that conclusion? Understanding he was applying the very law the council's been saying he did. I did want to note one thing in terms of the high probability. One of the cases cited by the defense was People v. Pierce at 114 Cal App 5th 508. And in Pierce they confirm that there has not been a fundamental change to the law. They say, quote, finally, we note that the defense contends the High Court in Reyes, quote, changed its position on the objective component of implied malice and redefined dangerous to human life as requiring a high probability that the defendant's act would result in death. Contrary to the defendant's argument, the requirement that an act carry, quote, a high probability of death is not new. And Reyes itself noted the equivalence of the Thomas and Phillips formulations, those which came before, restating that the language that already existed stood for the same thing. This is a refinement of the language. And in fact, in the Pierce
So why
case,
did 520 have to be changed?
no, because it's
I once had spit roasted oxen. It took forever, but it smelled amazing. Hey, Ruth Ann, happy Thanksgiving to you as well. Well, you're only saying it to the people in the Americas, but I took it and went with it.
stating that this already exists, that this is not new. This is the formulation. The change of 520 was a refinement in the language. The standard has always been that the failure to act, even from the previous language, the natural and probable consequences of the act were dangerous to human life.
That's not the same as, that's not as stringent as the requirement.
It is different language, but the point was that that was the language that was provided to, in this case, a jury. And the court upheld the conviction, stating that the language was sufficient based on what was provided to the jury at the time. So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed in isolation is not the determination. Watson.
Is that a spelling mistake in the name? Or have I got a new follower I didn't notice? I know Dodo, but maybe this is Dodo's sister.
All of its progeny, again and again, they don't provide
I think they're just very close to each other, next to each other. That's normally how it is in smaller courtrooms.
any definition of what implied malice is. They talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant was driving down an open road with no other vehicles, with no other cars, pedestrians, just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that that stretch of PCH, which the defendant said that he was familiar with, doesn't have sidewalks. This was all information known to the defendant.
I've never tried it that way. We had, when I was in Tenerife, we did have a meal that was cooked over a vent from. They have a volcano called Teide, and they put some grills over the vent from the magma chamber. Well, that's so far down, but still, you got all the heat from the volcano. So we had volcano roasted dinner up there. That was kind of weird, but that was one of those experiences you remember. I think we went there when I was 5 or 6 years old, and I thought that was that's a cool thing, getting volcano made food. You kind of sound like Lefty. Are you a Packers fan as well?
The time that he decided to engage in the behavior that he did. The speed that we're talking about has to be looked at in terms of where he was and what he was doing. It isn't just that he reached the speeds that he did, he also had to navigate around other vehicles that were going slower. And that evidence was presented at the preliminary hearing. And that he went around because
No, because you don't do it over the main chamber. It's just from one of the exhaust vents. So it's just heat that's and I don't again, I was 5 or 6 years old. I don't remember that it smelled a lot like sulfur down there. So it was just, it's a gimmick. It's kind of like with the geysers and stuff like that, that they can time it when they're gonna blow. It's just maybe it's more of a novelty than but our parents took us to a restaurant where they served it, and I don't know, that was kind of cool, especially when you're 5 6 years old. Christina, happy Thanksgiving to you. Well, it's not belated Thanksgiving. We don't even have Thanksgiving in Denmark, so that's why I am doing the Thanksgiving stream. So all of the good creators out there can get the turkey basted and then go on and make some food later, if you know what I mean. Because we don't have Thanksgiving, it's just a Thursday in my house, and just if someone needed somewhere to hang out this morning because they might not need to go get turkey basted or they have too many people, we do these every holiday where we try and give people a place to hang out, just because we know holidays can be a little lonesome for someone, or they can be shunned by the family, like Lefty, who is not allowed to be in America on Thanksgiving because no one would be thankful of that. I don't make the rules; the president does. It's when that's the reason why they pardon one of the turkeys, is because then they put its blame on Lefty and he has to leave the country for 24 hours so you can be thankful. Again, it's just science. But we know that some people might be a little lonely or maybe be a little bit overwhelmed because they have family coming in from 7 different states. So we do these holiday specials where people can come, hang out, and enjoy themselves. And there's no real programming. It's just yada-yadaing and seeing where we are going. Today, we're watching the AJ hearing where he wants to have charges dropped in the case from California with the guy who drove fast on, is it Pacific something highway, and unalived 4 girls, who was charged with murder, but he claims, well, that's an overcharge, which it also is, because people who have done exactly the same doesn't get charged with it. So that's what we're watching, and then probably we'll go back into the Baker is gonna ramble, so as long as chat give him something to ramble about later.
even according to him, the vehicle in front of him was in his lane, so he drove around. And that's when he was reaching those high speeds. Now, he claimed that that vehicle then started to merge
Pacific
into his
Coast
lane.
Highway. I knew it was something.
So first, let me talk about that in terms of my moving paper saying that about the cause of the accident. The defendant's conduct was the proximate cause of the accident, or the collision, I should say. There is not evidence presented at preliminary hearing or anywhere else, other than the defendant's statement, that there was any contact between the defendant's vehicle and another. And the physical evidence shows that that did not occur. I don't understand where
The mirror was damaged.
the mirror was.
It was out of place.
It was out of place. The mirror was out of place in a position that one would not expect to have happened if it occurred while the defendant was passing another vehicle. One would anticipate the mirror would be knocked back as it struck, as it's moving forward, and it would be knocked backwards. The defendant's mirror was knocked forward, and that was after he had exited his vehicle. I could not say exactly how that occurred, but it does not appear that it would have come from striking that other vehicle. And certainly, being the fact that the other vehicle suffered no damage on its mirror. The important point then is that this other vehicle is part of the issues that the defendant faces when he gets his vehicle up to the speeds that he did, because people change lanes. And if the defendant is attempting to pass on the right at speeds of 104 miles an hour, and the vehicle starts its turn, he does not have sufficient time in order to control his vehicle. And I did want to point out that the one thing that the defense didn't talk about was the fact that the defendant said when that vehicle came into his lane, he swerved to avoid it. We had the electronic data from the airbag system, and that was presented and put into evidence, and there was no swerving to what will be the light to the right. The only inputs were still left. The only steering inputs at all were to the left, contrary to what the defendant said. And as I noted in my moving papers,
Didn't he say the other car tried to pass him on the right? Or was he trying to pass a car on the right?
I won't go into great detail, but it does show that the defendant understood that what he was doing was dangerous, and he is coming up with excuses as to why the collision occurred. The other important factor about the speed and the electronic data control is that at the outset of its recording, which occurred 5 seconds prior to the first deployment of an airbag and some 7 seconds before the final deployment. Those inputs included an engagement of the stability control system, meaning the vehicle was not stable in its movement. In fact, we heard testimony at the preliminary hearing from Miguel Cucino that he observed the defendant's vehicle skid, lose traction with the road as he saw it then speed off. He said he could see the puff of smoke. According to the electronic data, that occurred when the defendant was doing 93 miles an hour and had his accelerator at 79%. He continued to accelerate for another 4 seconds after the vehicle lost traction with the road. As the court said, this isn't just he's going faster and doesn't notice, as Mr. Jackson said. He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above the limit, and continues on to what the data reported as 104 miles an hour. How could he not have known? In regards to the defense saying that we are relying simply on a slogan to prove that the defendant had subjective knowledge of the dangers of his speeding. It was the defendant himself in the statement who turned the slogan into something personal to him. That he had 2 of his best friends die as a result of speed. The defendant had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that.
Is that Karen Reed's car accidents defense attorney? This is not Karen Reed's attorney. The other one is Alan Jackson, who was her defense attorney in the murder trial with John O'Keefe. Yes.
The speed, and he said that he believed it was 130 miles an hour, caused the death of his two best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty, it is more than remote, or and I want to get the language right. In one of the citations, and this is from Reyes, citing People v. Cravens, the quote from a concurrence of Justice Liu, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive, we're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%. And as the court noted, this isn't just about the speed. It's about his knowledge and about where he is engaging in this excessive speed. And he said he knows PCH like the back of his hand. And he knows it like the back of his hand. He knows that people are putting out their trash cans. He knows that people are parallel parking. He knows that people cross on the crosswalk that is demonstrated in the exhibits that the defendant passed as part of his path towards where the collision took place. He knows this. And yet, with that knowledge, with the knowledge that he is already losing control of his vehicle due to speed, he continues to press down that accelerator for another 4 seconds. And that totality is the basis that the magistrate used to hold the defendant to answer. It is not that there has been no evidence, but there has been an abundance of evidence, that more so than is needed. But the point is,
I made a Mississippi mud pie that had marshmallows and chocolate, I believe. I don't believe that, well, I know there was no cream cheese in it because no cream cheese will enter this house. I think I might have some gelatin in it, but I think it was marshmallows. That I'm not, I think it was marshmallows. I made it for a lady. She appreciated it. Didn't give me any.
this hearing, it's whether that evidence was presented sufficient for the magistrate to hold the defendant to answer, and it was.
Very briefly, first of all, first thing I want to mention is that the math is wrong. And exceed the speed limit by 230%, the math is wrong. The speed limit was 45 or 50. 230% would be 145 miles an hour. Yes, no, sir. 100% is double. 100% on top of that is the 45 again. So let's get the math right. It wasn't. Was he speeding? Sure. But I don't want to get ridiculous about this. 230 times? I want to know, what the hell was he in a jet? You got the math wrong. Let's talk about the facts. Provable facts. Mr. Bartos says he was speeding. Okay? That's in a bucket. He's been saying that from day one. He's searching, and the prosecution has been searching and grasping at straws for anything other than that. There are homes at the side of PCH. That's dangerous. There are driveways leading out to PCH. That's also dangerous. There's cars parked along PCH. Boy, that's dangerous.
Hi, Baker. What are we watching? We are watching Alan Jackson in a motion hearing to try and remove 4 charges of murder against a young man who killed it's getting called the four sorority sisters dead. You know that it's clickbaity. But he was driving down the Pacific Coast Highway at excessive speeds, lost control of his vehicle, slammed into, I believe, another vehicle, or slammed into people and killed 4 people. This is not the first time this has happened on the Pacific Coast Highway, but this is the first time this has been charged as a murder case. Alan Jackson got on it, and it seems like a very political decision to charge him with murder. It's a manslaughter case. In every other case like this, it's manslaughter. But all of a sudden, because this kid does it in a fancy car and he lives in an area where people have some monies, then it seemed like a DA who was gunning for re-election chose to upcharge him. No one else has ever been charged like this, and this is why, as you can listen to Alan, he is a little bit upset to listen to. Queen of Hearts, thank you for being here as our favorite emotional support baker. Yes, you and Marissa should put Baker's Baddies in your merch store. Is Marissa having a merch store as well? That's mean lady. She's stealing my... I think if Marissa was awake at my night streams and heard what I said, she would probably say, I'm quitting. Luckily, she doesn't know what the Baker's Baddies are. I give her enough grief. All her gray hair are from me and her husband and her kid and her dogs. But thank you so much, Queen of Hearts. Baker's Baddies should be an annual competition. The ladies compete and Baker choose a baker's dozen to crown as his baddies. Oh my. Oh, well, is it a hands-on competition, if you know? No. Other streamers are getting in trouble with their fans. Bad Baker. Don't touch. As they say, don't shit where you eat and don't have smacks with people who contact you in DMs.
They're trash cans. People have to put their trash cans out. That's dangerous. There's no...
Yes, it was Miss J who said, hey, you should make a bomb pedal. And I made a bomb pedal. She wanted it studded. I made it a little more vanilla, but she was the inspiration to the Baker's Baddies bomb pedal. I did make an entire set of enjoyment tools, battery powered, in AI. And now, with seeing all the craziness going on today on the Twit and yesterday, I might need to get in touch with some Chinese adult entertainment production company and start selling that, because someone really needs to get a little going in the bathroom and just get it out of the system. Miss Jess is the Queen Baker Baddie. Oh my. Well, we're going to use her in the commercials.
Sidewalks, and yet there's still pedestrians across the street. It's also dangerous.
I'll be right back.
He went around some slower traffic, so says Mr. Bartos. Is that dangerous? Maybe, maybe not. And going at a higher rate of speed gives you less time to react. It's also dangerous. Where in that list did Mr. Bartos establish a high probability of death? That's the standard. The prosecution has gotten into this spin cycle non-stop since the preliminary hearing. Boy, this was dangerous, this seemed dangerous, this is dangerous, this is dangerous. That's not the law. As the court rightly termed, the jury instruction, it was changed for a reason. The Pierce case didn't stand for the proposition that it's all the same. It's always been a high probability of death. That's not true. The Reyes case changed the law. And the jury instruction was changed because of that, as the court noted. We are not talking about something that's dangerous. Is excessive speed dangerous? we go out on Van Nuys Boulevard, whatever the big boulevard is, I think Van Nuys Boulevard, outside the courthouse, how many folks are gonna be speeding on that road? Just, we can look for 10 minutes. How many folks are gonna be speeding on that road? Nearly all. Nearly all. It's California, for God's sake.
I don't like the way you're talking about Van Nuys.
Fair enough, fair enough. I'm making the point, but I don't mean to upset a community, but I'm making the point that speeding can be dangerous, probably is dangerous, but it doesn't in and of itself reflect a high probability of death.
What circumstances would, in your mind, represent a driving that evinces a high probability of death?
If he was high, but he was speeding, if he was...
Whether you're high, you're drunk, or whatever it might be, equally, and you're therefore likely to cause some kind of accident, who's to say whether this accident with drugs or that accident without drugs is more likely to happen to hit a vehicle or a pedestrian and kill them?
Let's say that there's a circumstance in which
Isn't there a large degree of bad luck?
luck is not enough. It has to be, yes. Sometimes accidents always happen to a certain degree because of bad luck. But the question becomes, when is it elevated to murder? That's why manslaughter exists. Judge, that's exactly what you're explaining is why manslaughter exists. Because sometimes people are doing things that are inherently dangerous, they shouldn't be doing it, it costs somebody their life. In every manslaughter case, it's important to reflect that I'm not standing up here asking that the entire case be dismissed. I'm saying let's call it what it is. In every single manslaughter case, every one, someone died. By definition, someone lost their life. If what Mr. Bartos is saying is right, basically, well, the car has a system on it that engaged. It was a traction control system. The car's telling him what he's doing is just about to lose control of the car. Well, first of all, that's not how traction control systems work. There's a beep that goes off or a light that goes off on the dashboard. You never hear it. I've got traction control in one of my cars, and you never know that it's going off or isn't. It's embedded in the EDR system, but it's not tapping the driver on the shoulder and saying, hey, slow down. That's not how it works. The question to answer the court's, the answer to the court's question is, what would show a high probability of death? Street racing. At 100 miles an hour on surface streets. High probability of death.
Why is that anymore?
Because
more
street
likely to
racing-
cause death than just driving 100 miles an hour?
Because street racing by definition is competitive, and you're constantly trying to outperform the other car. It's coordinated, and you're intending to go as fast as your car will possibly take you. That's the point of street racing. Street takeovers, where you're doing donuts, surrounding pedestrians. Nearly every one of those cases that's prosecuted, if a pedestrian gets clipped by a car drifting in circles, gets clipped and gets killed, nearly every one of those cases is prosecuted as a murder. Why? Because it's not just excessive speed, it's losing control of the car on purpose with a pedestrian
Not on
standing
purpose.
5.
It's not on purpose.
Drifting is losing control of the car going out of sorts. In other words, driving it in a manner in which it was not designed to be driven. It's drifting, by definition. So you have far less control. No car is designed specifically for that. It has to be in the hands of a professional. So these street takeovers, they kill people all the time. And normally those are prosecuted as murder cases. Why? Because it has the added effect. You're not just speeding like on the 405 to get around slower traffic. Driving on a sidewalk. Driving when you're evading police. There's always an additive to just speed. That's what Justice Evans was saying.
What about the environment? And Mr. Barker sort of touched on an example that I was going to raise as well, which is, don't you have to consider the environment and the circumstances? There's a difference in the risk of death in driving 100 on PCH versus, some, far out, desert road where you're on a straightaway, there's no other cars, and nobody's around, and you can just gun at 100 and not have to turn the wheel. There's a difference between that and driving on a dangerous crowded road like PCH, isn't there?
They're both dangerous. But neither one of those, by just driving fast alone, neither one of those include a high probability of death. People do it every day, Judge. On PCH, they do it every day and no one dies. It doesn't include a high probability of death. This is an incredibly high burden. We're not saying that it wasn't dangerous. I'm not suggesting that there wasn't a possibility that someone could get hurt. I'm saying that there was not a high probability of death such that Frazier Bohm should be saddled with murder charges. These are the same charges that Brian Koberger is facing. That's the point. Brian Koberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood. Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt? They did get hurt, so clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it. I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. But it wasn't murder. Thank you.
Thank you. Anything in response to that, Mr. Rogers?
The only thing is the evidence was sufficient for the magistrate, and he was correctly applying the facts to the correct law. And anything beyond that would be this court using its own decision-making, which is not the purpose of 1995. It's simply the determination whether there was evidence presented on which the magistrate could rely, and there was.
Submitted by both sides.
Submitted, Your Honor. Thank you.
Thank you. So first of all, the Church Council is aware, I'm going to put it on the record, made that standard 4995 motion. According to the ride-out of the Superior Court.
Oh yeah. I always get shit on when I mention that someone of the female persuasion looks bad in court. This guy looks like he's been on a 7-day bender. His hair looks as greasy as crusty panties, and I just don't think it's correct for a judge to look like this. I think you have to show up to court with a certain, I don't know, suasion. You can't preside over court looking like you've been drinking all week.
Case 67, Cal 2nd 471. Reasonable probable cause is shown if a man of ordinary caution or prudence would be led to believe and conscientiously entertain a strong suspicion of the guilt of the accused. That's the magistrate's job. The Mandela case, 1983, 33 Cal 3rd 754. Reaffirms that the magistrate's finding of probable cause should stand if supported by any rational interpretation of the evidence. If there is some evidence supporting the magistrate's conclusion, the information will not be set aside. Some evidence. People versus Superior Court, Decker, 2007 case, California Supreme Court case. The reviewing court asked whether the evidence provides a rational basis for believing the defendant could be guilty of the charged crime. Every legitimate inference that may be drawn from the evidence must be drawn in favor of the information. The judge, in my position, is not to reweigh the evidence or judge the credibility of witnesses. At the 995, the question is whether there was simply probable cause to hold the defendant to answer, and that's all. So I'm going to discuss facts here, and then I will discuss the law that applies to counts 1 through 4. There's no doubt the defendant was driving extremely fast on PCH. All of the witnesses describe it. They put different numbers on it, but they all said things like he was going, quote, extremely fast, or he, quote, flew past me, or he was going, quote, super fast, or that he, quote, accelerated extensively. The data recorder in Mr. Bohm's car said he was doing close to or even above 100 miles per hour in the instance before the crash in a 45 zone. The magistrate noted the data recorder evidence carried weight in his decision-making, acknowledging that while there are warnings that come with it that say it can make mistakes, there was no evidence presented at the preliminary hearing in this case that it made errors here. The defense said that Mr. Bohm was fleeing a road rage incident with Mr. Victor Calandra, but there's no evidence of that in the record. The evidence in the record was that Mr. Calandra, when stopped next to the defendant at a light a few moments before the crash, rolled down his window and warned the defendant he needed to be careful, yelling at him, "You need to be more careful, you're going to hurt yourself." Mr. Bohm did not respond. On cross-examination at the prelim, Mr. Calandra said he also included "slow down." He also said he might have said, "You're going to hurt yourself or someone." He said those things because he had seen the way the defendant was driving prior to stopping at that light. He testified the defendant was driving erratically and drifting extensively and speeding. Why else would he say those things to Mr. Bohm if he hadn't seen him driving in such a dangerous manner? That does not sound like road rage to me. The defendant did not even react to Mr. Calandra. When the defendant took off from the light, he zoomed away from Mr. Calandra, and there's no evidence that Mr. Calandra accelerated in any attempt to keep up with him and chase him. The attempt to back this defense theory of the case with evidence of a prior incident that Mr. Calandra was involved in did not succeed at the prelim, as Mr. Calandra's testimony was that in that prior incident, the other driver pulled him out of the vehicle and attacked him. Maybe other evidence will be discovered or developed as to that incident as this case goes forward, or maybe not. But the testimony at the preliminary hearing in this case was Mr. Calandra's recounting of it, and that was all. Defense also argues there's evidence that his driver's side mirror was hit somehow during this incident by a white car. Mr. Calandra's truck was bright blue. And that I think the argument is intended to be the contact with a white car was somehow causal of this crash. There is evidence that the mirror was damaged. The Ortiz sisters were both driving white vehicles, but neither said they had any contact with the defendant's vehicle. And both said the defendant zoomed off from the light and was way, way, way ahead of them at the time of the crash, which would undermine any causality if there was contact between one of those white vehicles and Mr. Bohm's vehicle. Mr. Calandra also said the defendant was several hundred yards ahead of him at the time of the crash, and his speed was excessive, at one point saying 80 to 85 miles an hour, and he did tell the detective it was maybe 70. Mr. I hope I'm not mispronouncing it, Scuccino said the defendant passed the white cars, was going very fast, and was perhaps as much as 600 meters ahead at the time he swerved and then the crash happened. No matter who's more accurate, it's clear the defendant was far, far ahead of all these other cars at the time he lost control of his vehicle, even if he had previously bumped into one of those cars and damaged his mirror, although there's really no evidence or no testimony that that happened, other than the defendant's statement to deputies later. As far as the evidence of the defendant's statements go, the most salient ones for purposes of this motion are that he understands the meaning of the aphorism, "speed kills," which he affirmed to deputies. But it wasn't just, "Yes, I know what that means. I saw it on a bus bench or the side of a bus," as you termed it, Mr. Jackson. He in particular knew what it meant because he said that his two best friends, as he described them, have been killed in a high-speed accident. And then he also said that he knows PCH, I'm quoting here, like the back of his hand, because he lives nearby and drives the PCH all the time. Well, if he knows the PCH that well, then he in particular would know how dangerous a road it is, how frequently accidents happen on it, and he would presumably know where a dead man's curve, where this accident happened, is. Those are the basic facts of the cases I gleaned them from the preliminary hearing transcript. Turning to the law, I'll just state it. Murder is the unlawful killing of a human being with malice aforethought. Malice may be either expressed or implied. It is expressed malice when the defendant manifests the deliberate intention to kill, which of course we do not have here. Malice is implied when the circumstances attending the killing show.
I think the problem is the microphone is too close to the court reporter. You can hear her shuffling around a lot.
A bandit and malignant heart. Malice should be implied when the killing proximately resulted from an act. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that would result in death. That is the new formulation. At the time he acted, this is continuing with the definition of implied malice, the defendant knew his act was dangerous to human life and he deliberately acted with conscious disregard for human life. Implied malice requires the defendant act with a wanton disregard for the high probability of death, thereby requiring a subjective awareness of a high degree of risk of death. It is not enough that a reasonable person would have been aware of the risk. Malice, importantly here, may be inferred from the circumstances, all of the circumstances of the incident. Calprin 520 defines implied malice has to be such that the natural and probable consequences of the act involve a high degree of probability that it would result in death, not merely a threat to or a conscious disregard for the safety of others, but that it would result in death. More than a possibility or a likelihood of death is required, the act itself must give rise to a high degree of probability that death would result. The defendant must
Oh, yeah, that's not a good one.
personally harbor implied malice. I'm aware of Carr, C-A-R-R case, which stated that the simple act of DUI is not enough for implied malice, that the defendant's actions before, during, and after the DUI were also relevant to the determination of whether malice existed. While a dangerous act may be insufficient by itself to establish that the actor had subjective knowledge of the risk, it may be a relevant consideration in finding malice. Importantly, implied malice is to be based on the totality of the circumstances before, during, and after the act. The prosecution must have proof specific to this defendant that shows his subjective mental state at the time of the act, that he knew and appreciated that his actions were dangerous to human life, and he deliberately acted with conscious disregard for human life. The prosecution, quite right, Mr. Jackson, must prove both the objective danger that the conduct presents to life, as well as the defendant's particularized subjective awareness of the risk of death emanating from his conduct and his disregarding of it. I don't think anyone could seriously contend that, objectively speaking, driving 100 miles an hour on PCH, other cars on the road, there are pedestrians, homes, restaurants, parked cars,
Yes,
people walking their dogs, and the like. I don't think anyone could seriously contend that the natural and probable consequences of that conduct in that environment, in that place, at that time, do not involve a high probability of death. Of course they do. What's difficult about this, and you sort of touched on this, Mr. Jackson, is it's very difficult to quantify the likelihood of death, because you're quite right. Sometimes people drive 100 and they don't have any accident at all. There's no way to know that because there's no accident, there's no reporting of it, and there's no statistics for it. So we're left to what we do have. The defense argument is that Mr. Bohm, knowing PCH like the back of his hand, as he said, cannot be said to have the subjective awareness that his speed would cause death, or highly probable would cause death. But if he knows the highway so well, it's reasonable to assume that he knows.
this will be a jury trial. Then why waste time pleading to this guy? Because they want the charges to be dismissed or lowered. Because if it goes to a jury trial and you go in for a murder too, again, as we always say, the likelihood of being found guilty is probably somewhere between 85 to 95% when you go in front of a jury. You would rather be found guilty in manslaughter than murder too. This is a pre-trial hearing. It's a pre-trial hearing. I think it's set to go. I'm not even sure. I think I looked it up, but I forgot. I'm sorry.
What a dangerous road it is. How many accidents, including fatal ones, occur on it. He knows what and where the advanced curve is. This familiarity with the PCH does supply him with the subjective knowledge that his actions on it are dangerous to human life, and the subjective appreciation of the substantial risk of his actions on that road in that moment. The substantial risk of that occurring. That personal, subjective awareness would have only been enhanced by Mr. Calandro's warning to him at the stoplight that he needed to slow down, or he was going to hurt himself or hurt someone, if he heard Mr. Calandro, which is not clear. I have reviewed the cases cited by both counsel in their motions. None of them are exactly like the classically Bowen case, but they do nevertheless provide guidance. And I know counsel discussed these a little bit, but I will as well. In People versus Canizales, 197, Calat 4, 832. The court held that the evidence was sufficient to find that and I know this was a pre-Reyes case, the court held that the evidence was sufficient to find that the defendants acted with conscious disregard for life, and therefore to convict them for second-degree murder. Rejecting the argument, there was no evidence that they were aware of the risk involved in their conduct. This is the case in which the defendants had modified their cars to engage in street races. They had consumed an unknown quantity of beer, raced side by side on a residential street, reaching speeds of up to 87 miles per hour, ran through a stop sign which they must have known was there, given that they lived just yards away. In addition, their callous disregard for the safety of others was shown by their failure, while the victims were being incinerated in their cars, their failure to show any remorse or concern, to try to help, or even to inquire about the condition. Instead, they tried to remove evidence. The court indicated the appellant, Mr. Canizales, was fully aware of the condition at the accident scene, which would make racing there very dangerous. They had long resided in the neighborhood, within yards of where the fatal crash was placed, and inferentially knew the residential nature of the neighborhood, the traffic conditions, and other factors. Mr. Canizales was seen driving recklessly in the area just before the collision. The court in Canizales referred to Justice Gilbert's remark in the Moore case, which our counsel also discussed, at 187 Calat 4, 937 and 941. Whether Moore was subjectively aware of the risk is best answered by the question, how could he not be? It takes no leap of logic for the jury to conclude that because anyone would be aware of the
Yes, this is the only case. That's why it's interesting, because again, he did kill these people through his stupid actions of driving too fast, but he is overcharged because it seems like a DA candidate or a DA just wanted to seem tough on crime, which again, as I say all the time, justice is blind. You don't charge someone for something you don't charge someone else with. Someone had a similar thing and then he left the scene, sped off to another state, and he only got manslaughter charges. So again, the justice system should be blind. Just because you drive a nice car and live in a wealthy neighborhood doesn't mean that you should be upcharged.
risk. Moore was aware of the risk. It got common sense as well. How could it not be? So going back to the Canizales opinion, the Court of Appeal stated the trial court pointed out that they were engaged in a speed contest at 80 or 90 miles per hour. How much more knowledge do they need? They've got several thousand pound vehicle that they're running at 70 or 80 miles an hour. What does it take for a person to understand that what they're doing is inherently dangerous to human life? Now here, Mr. Bowen was not involved in a street race with another person, but he certainly was driving at an absurdly high rate of speed to the data collector in his own vehicle. He'd also not drunk any alcohol, although Mr. Canizales was not stated to have been under the influence either. He had just consumed some amount of alcohol. just as Mr. Canizales was very familiar with the area in which he was driving, so was Mr. Bowman, by his own admission. Canizales was aware of the conditions of that roadway and he was driving like he did so dangerous to human life, and indeed likely to cause death. So was Mr. Bowman, due to his own familiarity with PCH. It should be noted that it was also a factor for the court in Canizales that defendant's post-crash conduct was deplorable, and that played into their evaluation of his subjective awareness and his callous disregard for human life. Mr. Bowman, it must be noted that
I think there's also a certain element of kind of like in the Koberger trial, the victims are also probably going to butcher it by explaining what I'm. It's a good PR stunt to put the victims out there and say, oh, look at these 4 young students who were young women who was just upon starting their life. And kind of like in the Koberger case, you got the right victims that you could sell a story on. That picture where they are standing out on the porch, that was a really good PR picture to go out there, put in the media, to drum up a lot of interest for a case like this, and you can sell it as a tough on crime DA.
demonstrated no such callousness after this accident. The Moore case, which I quoted some of a minute ago, also was instructive, I believe. In that case, the defendant drove through city streets at excessive speed. He passed one victim going 80 to 90 miles per hour in a 35 zone, ran a red light, collided with another car, which in turn hit a third car, causing the death of one victim and serious injury to another. The defendant did not get out of his car.
AJ being a prosecutor has no bearing on the trial because the jury don't know what AJ did. And again, it's always a crapshoot when you go in front of a jury. Look at the Karen Reed case. Not one single fact changed from the case 1 to 2, but the outcome changed. So it's very dependent on which jury he gets. It has nothing to do with his previous job. And as this judge is saying, his arguments didn't convince him. Will they convince a jury? I'm not sure. And it also depends on what leeway will he get to talk about other incidents that is like this. Because if they can't talk about other people who have done exactly the same thing but not being charged this harshly, then what are the chances to convince a jury? Where a jury will most likely convict someone if they are in court. And again, the facts are there. He did take 4 lives. And if the jury is in a bad mood, he'll get murder charges for that. The good thing in this is if they can argue that others have had only manslaughter charges, they will maybe go for the lesser included if they get manslaughter as the lesser included, which I think AJ will be fighting hard for. But the problem will be if you get the wrong jury and they see blood, doesn't matter how good a lawyer you are, because juries, it's not about the law, it's all about the fee-fees.
Victims but continued to drive. When he was arrested, he claimed he didn't intend to kill anyone and did not experience any mechanical failure.
In my opinion, Karen was way worse presented in the second trial. Those clips that she made, which to me, even with all the shit going on right now, the stupidest PR move made in the entire Karen Reed trial was making those interviews. When I saw them, I thought, oh my fucking God, Hank is going to turn her into a Karen, and this is going to burn her biscuits. Again, I don't trust the jury will look at the facts because the jury most likely will be run by their fee-fees. And those clips they used, even though I was annoyed because we all know it was bullshit, but we knew it because we've been following the case for 3 years, but the jury didn't. And I thought on a personal level, Karen, to me, looked way worse as a person in the second trial than in the first trial. I don't buy into that. Oh, she looks mad, or she smiled too much, or she was having a facial tick. Especially if there is someone on the jury stand, on the witness stand, the jury will be facing that person. All of that, her body language and body language is bullshit. You can be the most beautiful woman in the world with the brightest smile, and there will be someone saying, "Oh, you look fake," or you can look like a trash panda had sex with a manatee like Krusty, and some people can look at you and think, "Well, I'll make some babies on that one." It's I personally believe that Karen, as a person, was more damaged by the second trial than the first trial. Those facial expressions, I don't buy into it, because we know she's under a lot of stress. We know that she has certain illnesses that could give her a kind of a gaunt look. But those interview clips, to me, tarnished her reputation or her personality more than anything done in the courtroom.
But he said, "We're going too fast." And he admitted that he left the accident scene and did some of it.
No, I think she came off very unhinged and very Karen-like, if you can call it that. I didn't like the clips. I'm not a lawyer. I'm not a smart person, but the Karen Read defense team okaying those two interviews must be one of the biggest blunders in court history. Imagine if we didn't have all of these clips of Karen that Brennan could have played. The jury would probably just have said, "No, you don't. We just fill out the form here in the box."
Manner. The defendant there conceded in the front of the Moore case that the evidence was sufficient to support a finding of gross vehicular negligence, but claimed it was insufficient to show that he had subjective awareness of the risk for manslaughter. Justice Gilbert rejected this claim. He stated, "Moore drove 70 miles per hour and 45, crossed into the opposing traffic lane, caused oncoming drivers."
It doesn't matter. You have to stop making up these. Well, this is an excuse. It doesn't matter. It was presented in court. Yes, she Cannoni was a cunt. The jury didn't know that. The prejudice clips was words said by Karen. Karen made a disaster PR move. She opened up that they could go in and cut this. It's not because Hank Brennan did anything wrong. It's because the defense team lost their mind and thought Karen will be free after the first trial. Go talk to the press. It was idiotic, because everything you say can and will be used against you. It doesn't matter that it was cut to shit. It was played in court in front of a jury. And it couldn't have been played if you remember the first and only rule any defendant should remember. Shut the fuck up. Anything can and will be used against you. It's that simple. Karen made those clips. Well, it was out of context. Yeah, then the defense team should have gone in, played all of the context if it would have helped. It wouldn't. If she had just shut the fuck up and done that interview the week after she was found not guilty, she wouldn't have had it in court.
To avoid that, ran a red light and stopped the car in the intersection without even attempting to apply brakes. His actions went well beyond gross negligence. He acted with wanton disregard of the near certainty that someone would be killed. And that's at more at page 941. And I think about this, how is that so different from the evidence presented at the preliminary hearing in this case?
I'm not an attorney. I am an idiot.
It's not exactly the same. It doesn't have to be exactly the same. Mr. Bowen to drive at the very least 70, maybe it was 80 or 85, and the objective evidence says it was 100 in a 45 mile per hour zone. He was observed to be driving erratically, moving from lane to lane, causing another driver to at least attempt to warn him to slow down before he hurt someone or himself. Several other drivers also noticed his very, very fast driving, one of them, I believe, honking at him. While Mr. Boehm did not run a red light, he did commit very, very serious traffic violations here by speed alone. And I don't believe there was any evidence in this case that he applied his brakes either, not in terms of skids or that type of observable evidence of braking. And here, by his own admission, he knew how dangerous this was. His two friends, his best friends, were killed by driving at an excessive speed, extremely excessive speed. And he's very familiar with the PCH. And again, it's only reasonable to assume that due to that familiarity, he knows what a dangerous road it is, in particular the area called the Dead Man's Curve, where this accident occurred. The magistrate, Judge Edwards' findings that the elements of second-degree murder were satisfied for purposes of the preliminary hearing were well within the realm of the reasonable. The standard is not at prelim beyond a reasonable doubt. That's for trial. I'm not saying what the evidence will look like. If the case does go to trial, whether the case will be proven, whether the murder case will be proven beyond a reasonable doubt, or whether it won't, nobody knows the answer to that. But that's not a question for today. Question.
Hey, I've said it a million times. You can get Greenland. We pay them $500 million a year, and we still have to run their police, their schools, their health system, and their army. If you want them, you can take in. It's 50,000 people who. No, I can't say that on YouTube.
Today is whether there was sufficient evidence for the magistrate to make the findings that he did, including the inferences that he made. The law.
Well, if Nancy Disgrace is on the opposite side, I'm going to go bad for this kid.
That he applied, and I do believe that the magistrate's findings were well supported by the facts as they apply to the law that's applicable in this case. So the motion is respectfully done. All right. I'm going to take up Mr. Helfand's motion. Mr. Helfand?
Yes.
Yes.
The defense apparently subpoenaed Johan's phone to try to gain some information about his speed and his location, as well as any bias that he may have developed as a witness in this case. I haven't seen that actual subpoena, but that's what I'm surmising from the moving papers. Am I right about that?
It's attached to my declaration, Your Honor. I could have a if you want.
I don't know what they're talking about. It seems like a stupid motion that is not that important. I don't know if you remember in the beginning, I talked about the other side talking about YouTubers. An anonymous member, it's often if it's small, it's anonymous. I've been thinking about this, how to change the narrative. So many people who really don't know the details of the case think she's innocent just because they were told this and because it was proven in court. And maybe think it is the popular thing to be associated with. The Family Witness campaign needs to go on the offensive and get some local public figures, media, to speak up and support the truth. The truth is Karen Read was found not guilty. These YouTubers need to be exposed for what they are and the noise online drowned out. So he wants us horrible YouTubers, she wants us drowned out by getting their own team of local media, maybe Sue from Boston, if she can get off her high horse about anonymous Twitter accounts, will jump right on that and expose the truth that Karen Read was found not guilty. The evidence didn't convince the jury she was guilty. But I love that us YouTubers are the big problem. We were not in the courtroom. Well, we influenced the jury. Well, then Brennan was shitty at picking the jury because we didn't pick the jury. We didn't plant the jury. He was in the room. We didn't even know who was on the jury. But everything is always everyone else's fault, is what we are saying. Yeah, Sebastian, a lot of people need to move on. A lot of people need to move on, not just on that side, but in general, because oh my effing God, daddy gets tired. And not daddy in that way, but daddy as in the father who sits in the good chair in the living room and looks at you and say, oh, for heaven's sake, just shut up. But that was the hearing, of course, denied as every hearing always gets, but he has to make those requests to try and help his client. That grift boat has sailed. Well, I saw the new tactic. As you might know, there is a rift in the free care and read movement, and I'm just going to dig it deeper now by talking about it. Where certain people today on the Twitter thread has kind of announced who you can believe and who you can't believe, which I think is odd. I'm never on any of the lists. And at the same time are attacking people who has been strong supporters of Karen Read the entire way through. And claiming that we were only in it for the money. I don't know how many of you do things for free, but if I can get paid for doing what I'm doing right now, I don't mind it. To be honest, if I can get enough money that I can fly to Massachusetts and see some of you lovely people at some point, I would love to do that. I do spend a lot of time talking about a case. So if someone chooses to give me $5, like Mspire, and tell me a bad joke, and I might get a little bit more because there's more people watching. What is the problem in that? I didn't follow the Karen Read case to make money. I've never ever done my YouTube presentations because I'm big money baker. Because money on YouTube is nice and it comes sometimes and it doesn't come other times. I can do a night show, and if someone might be a little drunk or something, I can make a pretty good chunk of money, and I can do an 8-hour presentation and make $0. The grift is being a YouTuber. This is not my job, but I would like that I made so much money that I could live off of just doing YouTube. But we didn't get into the Karen Read case because we could make a ton of money. But that's the new thing, to try and make the divide bigger. Let's blame all of the people who are not singing the same song as us as just being grifters, because it worked so well for 2 years when the Antis did it. That's why I sell grifter merch, because they were only calling us grifters. I don't know who made this divide in the free care and read movement. You can blame whoever you want. I'm not a part of it. I don't get any DMs. I don't talk to anyone. And even if I did, I don't kiss and tell. I'm a virgin. I've never kissed anyone. But you need to stop trying to divide the audience. This is backfiring harder than it should. And it's going to hurt Karen Read in the long run that these people are trying to... to me, it just seems like they're trying to get rid of some competition so the real people can cover the Karen Read stuff and get you the real facts. Why do you want to diminish the audience? Because there's probably some people who won't use the official channels because they might not be the most interesting people, or they just have a style that you don't like. And it just seems to me that new movement, and I don't know if I hope that the rumors that Karen might have something to do with the choices being made right now on the Twits and the YouTubes. I hope she's not that stupid. Why take away big part of your PR group that we were for you? Just because some people, I don't know, got their little fifis hurt. Someone needs to come and stop all of this madness. People should stop DMing me and asking me to take sides. I'm not going to do it. I don't care. People should just stop this, because in the end, by singling out who is pure, you make other people's unpure. Every time you say something is haram or halal, you'll get people mad, and it's gonna hurt Karen Reed in the long run. Lisa Graham, thank you so much for 20 buckaroos, saying happy Thanksgiving and cheers to you. Cheers to all of you and a happy Thanksgiving. Remember, eat some turkey for me, because I don't eat much fowl. Mspire says, before I go to bed, why don't scientists trust atoms? Because they make up everything. You just want the rim shot. Thank you, Mspire. Every YouTuber is a grifter, calling other a grifter, Spider-Man meme. I am in 100% agreement, because everyone is here to try and make it big and get enough money to, I don't know, buy a keyboard. Maybe buy a bikini off the wish list of Twisted Tragedies. I'm so far behind. Danny, the pig lady. Super fun way to be cooking this morning. Thanks, Baker, from my family to yours. Go pet a pig for me. And say, Uncle Baker says, bacon. Happy Thanksgiving. Go Buckeyes. Minnesota Buckeyes. The only pure one is Runkle, in my opinion. Nothing wrong with grifting, though. Runkle is also grifting, because you go on and do a YouTube presentation, you're grifting. You might not be grifting for money. I will never mention that you can. I know my Nightbot will tell you that I have an offsite thing, and well, I can't say I never ever will, because maybe I'll make it so big that at some point I have to do the, hey, you have to pay a certain amount before I see it, and I'll read it, or else I'll read it at the end of the stream. Imagine if I got that big and famous, but I don't. But everyone is a grifter, because we're not doing YouTube because we don't want you to watch it. So we're just grifting views. That's why we do the nice thumbnails. That's why we do the clickbait titles to try and catch you. That's why we go and cover a topic where we know we're going to get some eyes on it. That's grifting as well. It's not just hey, do you know I have an Amazon wish list and I really want a party bus for my birthday? That's not grifting, in my opinion, alone. That's the negative grifting. But we are all grifters by the grace of God, because we need to be. If we don't, this is also grifting. Doing a stream on a day when no one else streams is good grifting, because you have nowhere else to be. So you can choose me today. Normally you would have Melanie, or you would have Recovery Addict, or you would have whoever. But Baker is a grifter, so he goes on when no one else is here, and because I don't celebrate Thanksgiving. Peach Geek just stopped in to say happy Thanksgiving. Thank you, and happy Thanksgiving to you as well. Hope you will get all the pecan pie that you can eat. And if you don't like pecan pie, eat some apple pie. I have never had pecan pie. I don't think I'm a fan of it. Getting ready for the big game today. Lions and Packers, going to be a great day. Lots of food. I'm watching the game today. Happy Thanksgiving to everyone. Nancy, are you Detroit Lions going up against lefties Green Bay Packers? I hope you win. Yes, always be grifting, because that is what it is. I don't like the, hey, did you know I have 35 off-screen? I don't mind that YouTube takes its cut, because I am just paying for YouTube to give me a platform. I don't. Everyone do what they do. I don't have a Venmo because it's not available in Denmark. And again, it's like Monopoly money until it's in my account. I don't care. It's like playing in the casino. You don't have the money till you cash out. And I don't mind people saying, hey, please support the channel. The grifting part is if you're sitting like Twisted Tragedies, constantly crying about how bad last week was. Fuck, girl, I had months where I lost 2/3 of my income on YouTube. Imagine if this was my job. Like Will said, when he took some personal time off, it hurts his bank account. So can't blame a brother for grifting. Well, we do that as well because we are lucky to be in a position where we have got a great audience, and we can then go and do stuff like that. But I'm not gonna lie. I don't mind that I don't have to cry every time I need a new screen or a ring light or something, because I have an amazing audience. That's why I keep my super chat talents, so I can remind myself how lucky I am. By the way, Carmen and I will be doing an unboxing video at some point, so you can see her new gear. And yes, it feels really good to raise money. Remember, Aiden's Defense Fund is linked in the top of the chat if anyone wants to contribute. That man is still facing 90 years in prison on bullshit charges, just as bullshit as we just saw in the case the hearing that we followed today. And I think maybe we need a reset, or maybe we need a divorce. I think we are about probably where we need a divorce, where some people just need to go to one side and say, okay, we're not going to go to your side of the playground anymore, but we're not going to shit on you because it hurts everyone. But the problem is some people seem really invested in shitting on someone else's playground, and I think it's stupid. Crazy to me, you could see yourself in a chargeback situation. Yes, I can't believe how it's legal that they can do it, especially because it's months. If you don't charge back within a certain amount of days, there shouldn't be this. It shouldn't be upon this. First of all, it should never be upon the streamer, because we don't get the money instantly into our accounts. It goes to YouTube and we'll be paid out at the end of the month. So YouTube have the money. And if you don't have a chargeback before they end, they'll stop on the FXZY day of the month, do all the tallying, and then they'll pay it out 2 weeks later. If you haven't charged back at that time, how can it be legal for you to come and say, well, 3 months ago, I paid $20 in Super Chat. I want that back. I couldn't do that if I found out that someone had used my card online that I didn't authorize. I couldn't go to my bank and say, hey, you have to stop that. Well, it's 3 months ago. We can't do anything now. That's not how it works, and I think that's. But again, who has the money to sue YouTube? Who is to say the service you provide meet the consumer's expectation, whereas with a physical product there is some measure of objectivity? Well, when you donate a super chat there, and I get a, are you sure you want to send this? and I actually have to go because all of my accounts are linked. So I have to go and punch in a code to buy anything online. With my business account, I have to go and approve it in the bank app. With my normal account, I have there's the payment service in Denmark. I will have to go and punch in my code and says, yes, I authorize these money to be withdrawn from my account. So I have twice said that I want to pay this money. Then how can you come back and say, why? Well, he didn't read my super chat in a funny Southern accent. That's I don't think that is a good thing. Hey, Josie and Isaac. I don't know who you are, but if you're friends of Sue, you're probably playing the banjo and saying, squeal, piggy, squeal. Sue made me say it in that accent. I would never ever say that about anyone I didn't know, but Sue asked me to say hi to you, and I bet you're lovely people, and I hope she's not too mean to you, as she is making my everyday a living hell by getting my mods to yell at me. Isaac and Josie, have a wonderful Thanksgiving, and just if she gets too annoying, chuck her in the pool, throw her a six-pack, and she'll calm down. I found out that works with her. Do you think the McAlberts is going to be successful with getting the case to federal court? Yes, it was sent to federal court yesterday. It has been approved. The problem is Proctor also accepting it? They say they have heard from him. The defense says we haven't heard, and it needs to be all defendants accepting going to federal. Probably one of your apparatus needs to be refreshed. What the hell is that emoji? Oh, it's beer. I thought, what the hell? I thought you were giving me the Sue bird. People have done that before. Oh, I'm on top chat. That doesn't help. That's why I can't find it. I need to get my new glasses. I see your comments. Was there anything else we need to talk about? It's almost 7 o'clock. I need to go make myself some dinner. Bum, 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 bum. I don't know if I have anything else we need to talk about. Do you have anything we need to talk about before I let you all go and have a gobble day? I need to go watch the Danish ladies are playing handball tonight. Any questions in the chat? Any comments in the chat that we need to go through before we end this shindig and go gravy hunting? Where do babies come from? That's a really easy answer. I have told this many a time, but I'll do it. Oh, maybe I have it. Do I have it here? Yes. This is where babies come from. you have the daddy bee and the mommy flower. And the daddy bee is flying around and saying, "Bzz, bzz, bzz." Hey, what's that over there? Bzz, bzz. And the mommy flower is saying, oh my petals are so pointy today. Oh, and it just rained yesterday, so I'm a little moist. I don't know what I'm looking for, but I like it. And then she hears, bzz, bzz, bzz. Well, and she says, I know where the cameras are. And then the little bee will pollinate the flower. And then 9 months later, a stork will fly through that flower field, and a small baby will attach itself to the stork, and the stork will fly out into the world. And at some point, because the stickiness of babies goes down over time, the baby will fall down, land at a house, and they have a new baby. Again, nothing but science. This is how babies are made. I know a lot of people don't understand. They think that it has to do with sexual intercourse and stuff like that. As a virgin with 2 children, I can tell you, you don't need to have sexual intercourse for having babies. Thank you, Twobble, saying, have a wonderful day. You too. I was just telling you where babies came from. It is a oh my. Well, he says, your wicked hat with with a flat ass. Full throated says, thanks for the biology lesson. My pleasure. This is a full service channel. I can teach you about almost anything. Just don't use it in your exams at school. On the playground, the boys yell, baby comes out your butt. I don't know. I wasn't in that end of the bed when my babies came. Some still believes the theory about dogs stepping on bees leading to babies. It's hilarious. People are just dumb. That's why you should watch the Baker channel, like Australia. Am I right? No, because the daddy bee is the one who pollinates, and then the mommy flower is the one. I just explained it. Some people just don't understand biology. Oh my God, I was voice texting. I swear that word did not come out of my mind. I apologize. It was supposed to find your way back. What? I have to go back and find that one. What did Miss Lily say? Now I have to find it. Was it a dirty word? Channel activity. Channel activity. What did you say? Guess I'm late. We'll catch replay. Happy Thanksgiving. Did you delete it? Sneaky. Sneaky, sneaky. I didn't see it. Why did I miss it? Thank you so much, Katie. Always love the Baker lesson. Well, I am here to serve. I am trying to teach all of you a little bit about biology. And I think it's the same in Korea. I'm not 100% sure. Maybe it's different over there. But thank you so much. I don't know why Miss Lily's. My mom, when I was younger, used to say they come from under your armpits. How can I tell you? How can I tell you? What? Well, mm. I said we can never leave you on your own because you'll never find your way back, meaning we love your sense of humor. Well, I will get lost in a phone booth. Good thing we don't have phone booths anymore. Going to have dinner. Thank you, Baker, for hosting this forum. Healthy Saving, having this presentation was my pleasure. You should all go and enjoy your Thanksgiving. And if you're not celebrating Thanksgiving, or you're just go watch my take on the bad PR move by the McAlberts. And if I can get to bed now, I don't have court tomorrow. I might try and get up and do a late night stream because I took care of your lonely mornings. And I know some of you ladies really like me for your lonely nights. Remember, Baker's Baddies? No, you don't. Baker's Baddies will be, as soon as I get a Smex toy maker, me and Miss Jessica will launch that new product line. Why do I say stuff like that? I'm such an idiot. You lovely Yanks. Iowa Buckeyes beat the Minnesota Wolverines. Detroit Lions go beat the Packers. Packers slam those Lions. And the rest of you, remember, it's okay to eat turkey, but don't mix meth and turkey.
I'm Jimmy. How y'all doing?
I know English is your second language, but you don't word
It's
your
my
questions
third,
carefully.
but I'm still better at it than you. You are
the most important people in this case that everybody seems to have forgotten in this